doing something causing 250 hours in legal fees to the city. Everybody else. What we do will cost a lot of money in legal fees if we do. But honestly, they got a point. I don't want it.
I may just go do that. Should I go do that?
But who says we can't legally find it?
Regularly scheduled meeting of the Planning Commission of the City of Annapolis is now called to order. It is, with my apologies, 9 minutes late. Madam Clerk, would you please call the roll?
Mr. Wallman?
Present.
Ms. Butler? Present. Mr. Pline?
Present.
Mr. Matthews? Mr. Harold?
Present.
Mr. Sale?
Present.
Mr. Imes?
Here.
Okay, we have more than a quorum and we're ready to go. We certainly need to take a look at the agenda for tonight. Are there any comments or questions on the agenda as it has been stated? Hearing none, I will ask if there's a motion to approve the agenda with, actually, I would like to make a change. I'd like to put new business at the end before adjournment. Any discussion on that? Any objection? Okay. Do I hear a motion to approve the agenda as amended?
I'd like to make a motion to approve the agenda as amended to move new business to the end before adjournment.
And do I have a second?
Second.
Okay. All in favor?
Aye.
All right, we're going to proceed. We have some minutes that we need to approve from, I believe it was May the 2nd. Do I have that right? I understand that there were some additions made by Ms. Butler. They've been incorporated by Ms. Hook, by the clerk, and
They're in bold.
they're in bold. Okay. They're on the top paragraph of page 2. Some bold additions on page 3. Although, okay. Anything, those changes acceptable? Do you hear a motion on these minutes?
So moved.
Second?
Second.
Okay. All in favor of approving the minutes as amended?
Aye.
Aye.
Okay. Done. There are no findings, I do not believe, that we need to approve or discuss or disapprove tonight. We can pass that by. And I would like to move, if we could, to the first order of major business here tonight, which is a discussion with respect to a request that was made that we revisit a finding that was made with respect to the Pastrana family properties, also known as Central Park. There are a couple of comments that I would like to make, I think, initially. First of all, this discussion is not about whether that's a good finding or not, good idea or not a good idea. You were talking about finding 22, which requires the applicant to bring a small spur pathway up to a fence, which is the property line between that property, the Pastrana property, and the neighboring Colony Heights property. And that's all that it does. It doesn't indicate that there should be vehicular car traffic through, as I saw in some of the letters that were submitted. It doesn't require at this time that that the fence be broached or breached, I guess that's the proper word. It only requires that in the future, if it does become a good idea, that then it is there. And the history behind this is a little, it's a bit unusual, not entirely unusual. That condition was added only during the discussion of the application itself. It was not a part of the original application. It was added, I don't know if people in the neighborhood ever took a look at the plans. They may have, they may not. There was nobody who came from the surrounding communities to comment at all on this application. And I would say that from the perspective of a citywide planning commission, that the notion of interconnection between communities is a value which has been expressed repeatedly over the years. That perhaps that interconnection it simply wasn't regarded during the application process by Pastrana. It was only seen at the last minute by one of the commissioners, and there was a discussion about it, and there were several facts which were not known, but at the time it was perceived that it was a good idea to keep the application moving, to be fair to the applicant, and that the addition of this slight spur to the property edge would not be of major importance, but could be held possibly for future use, but not at the moment until further staff work got done. So there was no intent on the part of the Planning Commission to sneak anything by anybody. It's just that we saw things that hadn't been seen during the application process by the Pastranas and the review by planning and zoning staff. And it seemed to be fairly minor. And so, in the interest of efficiency, there was a vote and a decision made that night, with the understanding that over time, over the years, that more investigation would be done on the advisability of this connection. And certain facts have arisen in the meantime. One of them is that the actual let me go back a step. The cul-de-sac actually reaches to the property line. It's like, I don't know if you remember geometry. Even when I was in the middle of geometry, I'm not sure that I remembered it very well. But if you might recall, there was this notion of the arc of a circle, and that if a line crossed it, that it would be almost an infinitesimal dimension. We have almost that situation here, in which the arc of the cul-de-sac of the street in question touches that fence line for something like 1.11 feet. Now, that's not wide enough for even a person to fit through, unless maybe they're thin and they go sideways. So clearly, if there were to be a connection, and I want to interject here, we have received many extremely well-written, passionate, factual letters And I can reassure or assure anybody in this audience that this is a hard-working bunch of citizen volunteers. And that the submissions which are made to us are read. So I'm not sure what's going to happen here tonight, but I think everybody here needs to understand that anything which was submitted in writing has been read. There's no need to repeat it. It's been absorbed. We get it. So in order for this connection, which I don't want to go into its pros and cons at this point, to be made, one would have to get a foot of easement from each of the two neighboring property owners, maybe 2 feet from one, whatever. Nobody really quite knows that. So in order for it to be, that would have to occur. And the other thing which has to occur is we have to understand who owns the fence, because it's not clear who owns the fence. And so, frankly, as it stands, if nothing is done, there'll be essentially no change in the status quo. And so there was a request made that we reconsider what our decision. And the first item on our agenda this evening is to determine under our own rules of procedure whether we can in fact reconsider this. But I want everyone to understand that no matter what decision we make, if things stay the same, they stay the same. If there's no change to the findings, essentially, it's the status quo. And if in 10 years things have changed and people want the connection and they can figure out a way to make things safe and everybody's in favor of it, then by gum, a connection can get made. But if we don't put that little spur in now, it won't ever get made. And from a little bit, also what we were told and learned at that hearing on the Pastrana application was that there are plans afoot to make a connection to Truxton Park. In other words, one could get from Colonial Heights, Colony Hills. Did I get it right?
We all live there, yeah.
All right.
You observed all of those letters.
Well, my memory ain't what it used to be, okay? Nor is my geometric understanding of things. But that there is, in the future, there may be a connection that's made to Truxton Park in which August Woods and Central Park and your neighborhood could, and your children could get there, and you could get there if you wanted to more easily. But that's not been made yet, and so that's all in the future. If you want it later, fine, and if you don't, things that will stay the same. With that information in mind, and is there anything planning staff would like to add to that? Any facts? No. Okay. I hope that I've stated them properly, and I apologize for getting the name of the neighborhood wrong. I would like to turn this over to a discussion about whether we can, in fact, even reconsider this. And I would, in order to inform that discussion, if with your permission, I would like to ask Mr. Elson, who's the Assistant City Solicitor, longtime attorney for the city, to render his, to see if he can illuminate the question for us.
Okay. Well, just a few minutes of recent history. At a Board of Appeals meeting in May, I believe it was, we went through the agenda, and Mr. Steve Kahn was sitting there in the background, and we invited him up because we didn't know why he was going to be there, why he was there. And so he told the Board of Appeals of the concern that the residents of the community have, and we listened to him, and then we informed him that he was before the wrong administrative agency of the city, but that, you know, we tried to give him some options as to what he could do, and the options really were to try to get in front of the Planning Commission and see if you could get on the agenda and explain what your concerns are. So we suggested to Steve that he submit a request for reconsideration because we didn't see any other way that this could get before the Planning Commission. There is a rule, or there are several rules about reconsideration in the Planning Commission rules that I'm going to go over in a minute. But the time had expired to take an appeal to the circuit court. Please, let me just explain, okay? The time had expired to take an appeal of the Planning Commission's decision to the circuit court. It's 30 days from the date of the decision, and when Steve approached the Board of Appeals, I believe it was more than 30 days at that time. So we gave him the only other option that is allowable by rule, and that is to try to get in front of the Planning Commission on a request for reconsideration, and it was submitted. And the staff talked to Steve, and we told him that we gave him the option of bifurcating the process before the Planning Commission, meaning that you could have at one hearing a determination, this discussion that's on the agenda as to whether the request can even lead to a public hearing, or to have that on the agenda plus the option of having a public hearing if the discussion results in a finding that there is a rule that will allow us to get into a public hearing. So the fees for the appeal application were, what, $100 and some odd dollars, was it, Cynthia?
200.
Or Sally? It was under $200, I think. So at any rate, Steve indicated that, you guys wanted to do the whole thing in one night, and that you all would contribute to the application fee, and that's where we're at right now. And so we have indicated on the agenda that the first thing that's going to happen tonight is a discussion amongst the Planning Commission members about the rule that's applicable here, or if there's more than one rule, the rules that are applicable, and that involves a legal question. And it's, in other words, does the rule legally allow the Planning Commission to go into a public hearing at this stage of the game on the request for reconsideration? Since that is a legal question, this is just a discussion amongst the members of the Planning Commission. If the Planning Commission members find that there is a rule that can lead to a public hearing on a request for reconsideration at this point in time, then there would be a public hearing at which the members of the community that is concerned here could come up to the podium and state what their concerns are. But we have to do this in a way that complies with the Planning Commission rules. And so therefore, I advise Bob, and I don't, if you all have your rules together, or I can read the rules to you. It's section 12 of the Planning Commission rules, which are the rules on reconsideration. And I'm going to read them into the record. So
Why don't you just read the two relevant ones?
Okay. Well, there's only one.
I'd like to be heard for a minute, because I understand
No, sir. We don't jump up and talk here.
And the fact pattern here will have bearing on how you discuss the rules.
No.
So I agree that
Sir.
it's a statutory and rules-based discussion.
Okay.
However, we should be heard to have the facts laid out there in public so that the rules can be applied to that fact pattern.
Okay, thank you.
Until such time as we do that, I think this is being done under the cover of darkness. Something
Okay.
is being snuck through, and this is nothing more than the mayor's boondoggle of the bike lane being foisted upon the neighbors, that my neighbors, and being extorted from this gentleman back here who's trying to get a development done.
All right, thank you, sir. Thank you.
Facts are applicable to the rules.
Thank you. Thank you. We hear your conclusions, and thank you.
Discussion point 22 was void ab initio. You had a material misunderstanding of what the facts were. You admitted it yourself in this discussion here today. You thought there was enough room, there wasn't. There's a material misunderstanding of fact. And you cannot go forward with this.
Thank you.
Well, thank you.
Just so we know as a community, what was your,
Listen, wait a minute, wait.
Let that we should appeal.
This is not going to become a shouting match.
Right, but I'm just wondering, what
Then
if
fine, I'll be glad to adjourn the meeting.
Us, who let us know that we have 30 days to appeal. That's all I'm asking. That's a simple question. What is your responsibility?
You'll have to
to let us know that we have 30 days to appeal.
Please.
That's it. I mean, if you are telling us your responsibility, your rules, we need to know what you're giving up.
Mr. Chairman, could we explain to the people that if we don't follow parliamentary procedure, we can't have a good legal meeting that won't stick, and then this will just keep cascading. So if we could rehash that, maybe everybody would understand that we have to follow the parliamentary procedure.
You know, Mr. Khan had the opportunity to find out what the rules are. It's not my job to educate and inform everybody in this room as to what the rules of procedure are.
But how do you have a legal discussion with parliamentary procedure when it's clear you didn't even follow the law to start with? I'm sorry. This guy is right.
Well, I will beg to differ with you.
On this and act like we actually live here.
We did. That's the thing. We followed our rules of procedure, and nobody was here, and we went forward.
Nobody did.
Let us know. You need to do your
It didn't come upon you to notify the neighborhood of things happening.
Well, there's something I need to explain, a difference. The applicant is required to notify people, every resident, within 200 feet.
Nobody has noticed on our street. It's running through our street. Nobody was notified.
Where is this notification?
It wasn't that hard. It's not a big street.
I do not have the application in front of me. Ms. Godinez is the staff planner who handled the application. Could you describe what the rules of procedure are for notification to the surrounding residents?
They're notified of the hearing within property owners within 200 feet of the subject property.
Okay.
And then as far as the decision, anyone who's made comment, shown up to the hearing, get a notification of the decision. And the applicant.
Anybody who showed up at the hearing and who testified gets a notification.
Yes, if they provide their
of the
email and
decision.
address, they get the notification of the decision.
And so, who is responsible for notifying the residents?
Initially for the project or for the hearing?
Yes.
That's the applicant, and they provide a list of the property owners within 200 feet. They provide an affidavit of mailing, and that was done.
Okay. And was that made a part of the application?
Yes, it's part of the file record.
Okay. So, in fact, sir, listen.
They had to rules surrounding the imposition of condition 22. Let's not even go back to the notices. Why was condition 22 foisted upon this individual, this applicant, in order to get a bike lane for the pedestrian and everybody in the community?
Well, as I have tried to explain before, and as I will explain again, okay? Nothing. The application came in, and during the discussion on it, it became clear that there was the opportunity for making that connection. It was not a part of the original proposal by the applicant, by Pastrana. And so during the discussion about this, that opportunity became evident. And there was discussion about whether it could be done and whether it was a good idea. And once again, I remind you that nobody was here, so we couldn't hear. It is not unusual. Okay, it is not It is not unusual to add conditions to an application. So it's not unusual. This was the only condition that was added. Otherwise, the proposal was fully vetted and went through. So one of the things that concerns me here is that this is turning into a formless discussion. And I don't think it's a good idea that it be formless. So one of the things that we could do is we could take a 5 to 10 minute break and calm down a little bit and decide how we're going to proceed, how the commission can decide how it wants to proceed after we reconvene. It's,
During that 5 to 10 minute break, can we see who's within the 200 feet of the property? Stephen has a list right.
use the time profitably.
We
Go.
already started 12 minutes late. You guys are
Okay.
wasting your time.
If that makes sense. It is now. It is.
You didn't follow the appeals procedure. It's not that complicated. You guys didn't let us know like you should have. We couldn't do. Clearly, we are here to appeal. Clearly, we're here to appeal. If we had been notified within those 30 days, these same people would have showed up. That is what we're saying. So your system is not working because we were not notified.
It is now 7:38. At 7:48, we'll reconvene. Thank you.
There you go.
So my feeling is that, at this point, I would just say that you're taking off the agenda tonight because they can't control themselves. And we
You don't impose a requirement on the applicant to dedicate the space as a sidewalk.
Everybody, mic off. Your mic off. Turn your mic off, please.
Fellow commissioners, are you ready to proceed? Yes. I was informed by staff that I did in fact misspeak about something, and that is the hearing on this project took place in November. I don't have in front of me the minutes of the meeting of that night, but I was informed by staff that somebody did come and speak about the application and potentially about this issue. Personally, I don't know whether that person was informed of the ultimate decision or not. But I would like to clarify a couple of more things and to repeat a couple of things. The notice that has to go out initially of the hearing, of that there's an application and that there will be a hearing before the Planning Commission, is posted and sent out to residents within 200 feet by the applicant.
Wait, please.
If there's going to be interruptions, then I think that we have other business to do tonight. We've put this on as an accommodation, and maybe we'll have to find some other time, but we really need to act like adults here. I can only say that in having reviewed dozens of applications over the years, that the applicants and their attorneys know how to post notices, that this applicant was represented by a lawyer who's represented dozens and dozens of people. He well knows the rules. He's the kind of guy who does follow those kinds of rules. And you may not have be within 200 feet. I can't answer to that, but there was no objection raised at the time that it hadn't been done. Staff was satisfied. Now, wait a minute. What happens is that there's a decision made in November. Okay? When you talk about appeal, the appeal that's spoken of in the rules is not an appeal to us. The appeal is made to the Circuit Court for Anne Arundel County. Okay? And there's nothing anywhere in the code, there's nothing in the city code, and believe me, there won't be anything similar in the county code, that requires anybody, the applicant or the planning staff of the planning department or the planning commission or anybody, to notify the same people within 200 feet that there was a decision. There's no requirement. People are notified that there's a hearing, a decision will be made. It's up to them whether they come or not. Now, I also want to say, but interestingly, that since that time, we changed the rules so that there are community meetings that are obligated onto the applicant to hold. But this happened before that change in the law. And we changed the law because of circumstances like this. So, I would like to hear from the commissioners as to what they think, what each of you would like to do here.
I first would like to get some legal questions in my mind answered from our city attorney. If a condition is made and then the applicant accepts it, and I'm going to try to put everything in layman's terms because I am a layman. That's the only way I understand these things. So a condition was made by us. The applicant then accepts that condition, which they have. That condition, let's say there was some other reason to remove it. Is there a way to remove a condition, or is there some stopgap after us of someone removing a condition that maybe we didn't know was maybe ludicrous or some other way?
Well, okay, so I can answer the question. For the first thing you do is you look at the Planning Commission's rules. The boards and commissions of the City of Annapolis have rules. And so the other thing that you could do is consider the fact that any board or commission has I think the inherent authority to adjust or tweak or, in some way change a condition or leave it as is without a request for reconsideration. The reason is is when the Planning Commission feels that there's a necessity for it. Now, you can't do it 2 years from now because there's reliance by the applicant. At some point, the approval that the Planning Commission gives to the applicant vests in the applicant. So it doesn't go on indefinitely. But in the beginning stages, before an applicant has started construction, or if the applicant is still in the permitting phase, and the applicant, it's not going to unfairly prejudice the applicant because all of a sudden there's a change and the applicant, for instance, has spent a lot of money doing certain things in reliance on the decision of the Planning Commission, then all of a sudden it's changed. The law doesn't allow the Planning Commission to have that type of authority because at some point it does vest, the approval does vest, meaning that you can't take the approval away in any sense of the word. But vesting in a situation like this, in zoning vesting, the vesting doesn't occur until there is some commencement of construction.
Which has not occurred yet.
So you don't it has not vested.
So we have a condition that has been put out there, and as I recall, the developer didn't really want to do it, but was not really averse to it either because it's a tiny little bike pavement spur, which could technically be 1 inch. Could be that's technically a paved spur. There was no length given. So I wouldn't think this is that big of a thing of a condition to remove. But how would we legally remove that condition? By just recommending it to the applicant, and if the applicant then accepts it, then it becomes removed in essence by the applicant?
I think if there's consent from the applicant, and the applicant's attorney is here tonight, one of the attorneys for the applicant is here tonight, if there's consent from the applicant, I think the chair has the inherent authority to do what is fair, just, as long as it doesn't prejudice the applicant or take away something from the applicant that's vested. There is not vesting yet in this approval.
But we do have to have a reason for removing it.
Well, you can't do it arbitrarily, so you do have to have a reason.
So we have to have a somewhat solid reason. We got to come up with if we were to remove. So there is a way to remove
you
it.
can
without reopening a hearing and going through that legal
I'm not sure this
issue.
Yes.
You know, you have to do it in a way.
The rules do not require a hearing to reconsider the findings.
Because the applicant doesn't want that.
Well, there's got to be due process first. So the applicant's attorney's here. So the applicant can consent on behalf of the client. If the applicant can do that, it obviates the need for, any further due process, I think. So you can eliminate it, you can keep it. Condition 22, you can tweak it, you can amend it, adjust it, revise it, change it. Anything along those lines.
Okay, thank you.
You're welcome.
Could we ask the applicant's attorney a question?
I'd like to hear, is that, what's the question?
Where this proposed spur is, if that were not there, would that be part of communal property of the development, or would that be essentially part of the plat of somebody's property?
It would be in common area.
It would be common area.
On someone's lot.
Okay, so whether there's a spur there or not, it's not going to be somebody's backyard. It's going to be common property for the development.
Let me pull the plans up 1 second.
Okay. Because I would offer an amendment.
Wait.
Oh, okay. All right.
Get his plans out and let him identify himself, too.
Yeah, really. Who is it? Who's speaking?
Stephen Hyatt Weber on behalf of the Pastrana Central Park plan development applicant.
Can you make sure your mic is on?
It's on. Yeah.
I gather you're joined by a representative of the applicant? Madam, would you,
Mr. Klein?
Madam, you're, wait.
Sorry.
Would you identify yourself, please?
Sorry, Laura Gill Pastrana with Pastrana Properties.
Thank you.
The spur would be along a separate trail that's going to be behind several lots, but it would not be on someone's lot or in anyone's specific backyard.
So that would be under the control of the homeowners
Correct.
association. Okay.
I'd like, with reference to following that question, Ms. Godinez, about how long is this spur we've been talking about?
I don't think it's...
It was hard to tell from the,
Would you like me to provide the condition to the attorney? That way he's got it right in front of him. You want?
Pardon me?
I have the condition for the attorney.
I have it.
Okay, just make sure you got it.
Thank you.
Just to clarify something in the meantime, this was the December meeting that this actually occurred, and there were 4 people plus the alderman who spoke.
Right. And
I've got the minutes here if you need them.
Right. I would like to thank Ms. Hook, or the clerk, who reached back into her computer, saw those names, and yes, there were 4 people in addition to an alderman.
The spur, as currently shown on the final plat that has been submitted but not fully reviewed yet, shows that I don't have a scale here, but I would say it's approximately, it's kind of at an angle, so 15 to 20 feet long, maybe.
Okay. Okay, and
What
about
is
how
it-
far wide?
Pardon me?
3 feet wide?
No, the easement is 12 feet. The actual path is proposed to be at 10 feet.
10 feet?
10 feet wide, not necessarily at that point, but the main path.
Oh,
If
you mean
read
not the path, not the spur we're talking about, but
If
the
you-
main path?
if you
Something
read-
different?
Yes, but it's all part of a bike pedestrian path.
Right, but it's something
if-
different. The spur itself
You
is-
should read condition 22 to see the wording about the spur, which was part of Dr. Nash's memo that she
I
sent.
have it here. Would you like me to read it, Mr. Chairman?
Yes, because
Tell me
it's
if I'm,
brief.
stop me if I'm wrong. It's only 3 lines long. This condition states, applicant shall provide for a paved spur off the proposed bike lane for access to the right-of-way of Colony Drive. The exact location of the spur to be determined by the Department of Planning and Zoning.
That's correct.
So I don't see any definition in there of how long it has to be. It could be an inch. It could be an inch wide. Is that, I mean, I don't
Yes,
see-
that specific condition does not state how wide it needs to be, but other descriptions of the path are a 10-foot paved pathway with a, and the plat shows a 12-foot wide easement. Again, this is
But
the
that's
final
not
plat.
what, pardon me for interrupting, but that's
Sure.
not what we're talking about. That's different. The spur is something else, which is...
The spur
could be-
is strictly based on that condition 22 that was added by the Planning Commission.
Right. So it would be no more than necessary for a pedestrian or a bicyclist.
That would be the
Okay.
minimum, obviously.
If in fact it's built, but that's,
Correct. You would have to
Okay.
have a minimum of probably at least 3 to 4 feet. 4 feet's a standard sidewalk, so 3 feet. You know, you can have paths that are 3 feet wide.
And the
but usually
proposed design of the spur ends in what? What's at the end of that spur right now? There's no proposed, that's a good point.
There is a submitted final plat that addressed that condition. That plat has not been approved nor fully reviewed. I do have a copy of it, or parts of that plat,
Okay.
that show this spur. Like I said, it currently appears to be 15 to 20 feet long. It's at an angle, so One part of it is longer than another part. And they currently propose the width of the easement for that path at 12 feet wide. But as previously noted, the actual area of connection between the Pastrana property and the right-of-way is only just over a foot.
There's only what?
Just over a foot, that 1.11 feet.
And if you have experience with this, what's the minimum width that's required, that's advisable for a pedestrian path?
Well, like I said, a sidewalk's usually like 4 feet wide.
Okay, but are there, I mean,
There's paths that are, like I said, 3 feet's usually a minimum.
yeah.
Minimum
okay.
3 feet, generally
Okay.
speaking. But they can be, if you want, people passing on both sides, bicycle traffic, of course, they get wider when you have multimodal
Okay,
paths.
thank you.
So
Anything further, please?
does this mean that if we wanted to make a path through there, and if the city eventually wanted to do some kind of path through there, they'd already have the 1.1 of the Pastrana property, set aside. They could, go from there.
They have an easement set aside?
But
There's an easement showing on the plat of a 12-foot wide area, but only 1.11 feet of that would touch the right-of-way.
Yeah.
The rest of that would touch the other property owners along Colony
so
Drive.
they'd have to go over that obstacle of getting an easement from the other property owners.
Correct.
Before we
Someone
could
would
even
have
do
to
anything.
get, correct. Someone would have to get an easement or multiple easements from those property owners
Seems
to make
that
a wide enough path. There's also, one thing that hasn't been discussed is there's also current vegetation there. So potential that vegetation would have to be removed to create the path as well. That
Trees?
vegetation's been there, pardon me?
Trees?
Yes.
Trees.
So
hey.
this is just this is just while we're working on this project. This is one easement we can get right now. One foot that we can get right now, and then if later on we need something, we don't have to go through different easements. That's one that the city wouldn't, not us. The city wouldn't have to worry about.
That's one possibility, is just to have this as an easement for the future, if, future connection makes sense for that area. But at the current time, it's not really feasible due to potentially vegetation, the fence issue, the width of the connection along Colony Drive with the Pastrana property. It's not really feasible at this time.
So there's nothing about cutting through any properties at this point.
No, we can't just cut through people's property.
I heard it from the crowd.
So if there was going to be any path in the future, would there be notice given to the public and a hearing?
We'd have to get easements, like I said.
You'd have to get easements. So
Right, you'd have to
it
get
would
easements for-
involve community meetings and
Can I
community.
comment on that?
I don't know.
That's all hypothetical.
Yes. Thank you.
Thank you.
It's very hypothetical. It's not something that necessarily would come before the Planning Commission. It's just property owners would be contacted. If they're willing to grant an easement, fine. If they're not willing to, that's fine too. I mean, we can't force an easement on anybody. And the question is whether it would be the city seeking an easement or the homeowners association seeking the easement, because it's the homeowners association property. So these things cannot be determined with any in any definite manner right now. There is no way to do that. If the situation arises in the future where it's something to be considered, then it's dealt with at that time. But there is no easement that's going to be forced on anybody, and everybody in this room knows that.
So if I may offer a motion to amend this finding.
I had one more question before that. Is in the plat is submitted, what type of pavement is going to be the pathway?
Pardon me?
What type of pavement is the pathway in the plat?
It doesn't show the type of pavement on
They
the
don't.
plat.
It's probably going to be asphalt, and Lord knows we don't need any more of that sitting around for 20 years.
Ms.
I
Godinez.
don't remember what we required as far as the pavement off the top of my
Okay,
head.
thank you.
I'd like to ask the applicant this question. You already readily agreed to provide this paved spur, correct?
That's correct.
Would you agree to, instead of a paved spur, grant to the city the same easement that would be required by a paved spur? put it on the plat, and we'll leave it there for future consideration.
Hypothetically, yes.
Thank you. How can we make that not a hypothetical?
Yeah.
It's very simple.
I think that
Instead of paving a spur and granting people access, what you would do is grant the same easement which is already on the plat map.
Excuse me, it's already on the plat that they've submitted.
It's already
for review
on the plat that's submitted.
as a, as an easement.
Okay.
So
So it's already there. So
Essentially-
we've passed from hypothetical to already
Right, so
accomplished.
essentially, my concern is if we don't build the spur as condition 22 says, that we won't be in compliance with our
Oh, I understand.
approvals, right? So
I understand. I suggest that you hold on.
Yeah.
Hold on.
So-
Because it occurs to me that given the situation that we have here, okay, I don't think I need to describe what we have, but what we have, we've heard it all. We have an almost impossibility at this point. We have vegetation. We have people who are very concerned about having something sort of presented to them without any input. And then there's always the future possibility that lives and people's and minds change. And an easement has already been granted.
Is it a public easement or a private easement?
It's a easement that's the homeowners.
Yeah.
It's an easement that just goes to the edge of the property for the spur. That's it.
But it's not granted to the city or dedicated to the city,
No,
is it?
it's actually part of the homeowners
Yeah.
association.
But it's an easement that grants access to that path, does it not?
Correct. It does grant, the easement
Public
does
access.
grant public access. That's
Okay.
correct. It does.
Okay. So if I may I?
You're the chair.
I'm going to ask Mr. Elson to help me with the wording of this, that the motion that I'm proposing is that we modify condition 22 to read as follows. That the applicant shall provide, reserve, or grant, or you give me the right verb, an easement for public, pedestrian, and bicycle access to the right-of-way of Colony Drive, the exact location to be determined by the Department of Planning and Zoning. So basically what I'm saying here is just put the easement on paper, put it on the plat, let life go on, and if there are changes in the future, the easement is there for us to make, for use to be made of it, if that's what people decide. Is that where we're going?
I wouldn't have phrased it quite like that.
How would you?
What I was going to propose as a change to condition 20 is the applicant shall provide for an easement off the proposed bike lane that runs in the back of the property for possible future access to the right-of-way of Colony Drive, period.
Okay, same thing, just an easement.
Right. So I wanted to make the motion and then get into discussion and then say a couple words about that, because I'm the one that brought this up in the first place, so I thought it was important that I talk about that. So,
Point of interest, Mr. Chairman?
So,
Point of interest, for some clarification, how are you planning to modify the already finally approved appeals period closed and told decision?
well, how am I planning to do it?
Yes.
I'm planning to use my powers, or the powers of the Planning Commission, that under good cause shown, it can reconsider something. And that the time requirements apply to the applicant. It doesn't say that it applies to everybody. I'm going to presume that it applies to everybody, but I'm very sure that it applies to the applicant. So I think that given the circumstances, I think that this is a way to proceed.
My only worry is opening this. Are we going to end up back here on another discussion point?
This is the only thing that's been raised, the only topic of discussion. It's the only thing that I think is on our agenda for okay? It's the only condition that was added beyond the normal conditions of any application. So I think you need not worry that it's going to metastasize into something major.
Well,
okay?
But just again, for clarification, Mr. Chairman, you're saying that the time frames to appeal only apply to the applicant?
I'm saying it clearly applies to the applicant. I'm not
Not
sure
to the
about
commission?
others. But is that your question?
Yes.
That's your answer. It does clearly apply to the applicant, and it's unclear as to what members of the public it does apply. As Mr. Elson did opine, though, that there's some finality to this whole thing, and that your application is very close to vesting, so I don't think that I would be too concerned.
Well, it would restart another appeals period.
Well, I can't help you with that.
Well, I don't think that you have, as the commission, under your own rules, the authority to reopen a finally approved decision where it spells out specific timeframes for which reconsiderations must occur.
Okay, I understand what your concern is. Do you understand?
Well, yeah, first of all, the time frame is only on one of the 4 standards for reconsideration. Let me get the rule out. Here it is. Okay. And that is at the next meeting. We're way beyond the next meeting. So, but the first 3 rules for reconsideration don't have a time frame in there. But on the other hand, like I said before, the Planning Commission wouldn't be able to change anything after vesting, but it's not vested yet.
I don't think that there's an issue because if I can read it out loud, it'll probably just confuse everybody. But 12.2, the Planning Commission may reconsider its decision on an application. Mr. Hyatt.
I'm listening, sorry.
This is 12.2.
Yep.
The Planning Commission may reconsider its decision on an application when there is a clear showing that certain pertinent and significant new evidence relevant to the Planning Commission's decision on the application could not reasonably have been discovered by an applicant. Okay? You couldn't have reasonably discovered what the condition that we proposed.
We did discover it.
No, you couldn't have.
How's that?
You couldn't have. Don't worry.
I am worried, and I would like clarification, please.
Excuse me?
I would like, how could we not have discovered what we did discover?
No, it's because the condition was added only at the hearing. It was not evidence that you could have discovered. You're not at any fault for not having discovered something which came from left field. Okay?
Okay.
Okay. So I'm beginning to feel comfortable with our abilities to reconsider our findings. I think in light of all of the evidence which has been submitted on paper and not placing much on the oral testimony, so the oral shouting tonight.
I just have one more question for the applicant attorney. You can finish that point if you want.
Go ahead.
But my question would be, do you have a different view from what you've just said, whether the condition 22 is amended or removed completely?
I think that the condition can be satisfied in a way that pleases the Colony Hills community by working with planning and zoning to essentially say that under this condition, by, I don't know, stubbing in off of the bike path, a future path under this condition, we don't have to build it today, satisfies condition 22.
Right, but I kind of see what you're talking about, because those 3 sentences I read earlier are very, may I say, not
broad,
not specific.
Yes.
It's very broad. So it doesn't say you have to give an easement. It doesn't say you have to pave anything more than make a paved spur. A paved spur could be a millimeter.
Correct.
So the easement doesn't have to be in there, I don't think, for condition 22. Now, all the pros, correct me if I'm wrong. And the paving doesn't really have to occur. So it basically is the same bike path that before we made this condition, just not with a spur, but yet the condition still stays there.
Yeah, I mean,
technically it
it's
has
essentially even if it were to be built all the way to the fence, it's a bike path to nowhere. We could make it 1 millimeter, 1 foot. It's not going past the fence, and we would just have to work, as it says in the condition, with planning and zoning to agree on what they will accept that satisfies that condition.
So to make it, I think, plain to the audience, as an applicant, you don't want to open up yourself to a whole new, maybe appeals process, 30 days, reapplying. You'd like to keep what you've already had put forward.
Correct.
which means condition 22 still stands. It's just you work with planning and zoning and the
Essentially,
community
to not build it.
to give them what they want, which is what you just
That's
said.
exactly
probably.
right.
Okay, my comments are done.
And let me add that, and this is the reason I asked this question, is because in these kinds of situations, what often happens is the possibility of any connection ever in the future goes away when some piece of land gets sold and it becomes somebody's property. And that's why I asked you that question. But given that you said that this would be owned by the homeowners association, I think it doesn't really matter if nothing happens. And, you know, a millimeter of whatever is said in this condition happens. It does provide in the future, if the homeowners association of Central Park and the Colony Hills folks in 25 years decide, geez, I wish I could walk to see my neighbor, and they decide mutually that they want to do that, they can do that, and it's not walking through somebody's backyard. And so,
but they could do something in the future.
I think I hope we're at some sort of common understanding here that provides that capability for later, if it's mutually acceptable. But does not essentially foist something on somebody that they don't want right now, and doesn't get us afoul of whatever rules we have.
Just procedurally, do you have a motion on the floor? Were you just considering a motion?
Well, no.
I stopped that motion for talking because I didn't want the motion to occur, so I stopped Mr. Pline from putting a motion.
Okay, so I was just trying to keep track of who had the ball.
So I think where we are at the moment is, would the Colony Hills community take Mr. Hyatt's word for what he said he would do?
I'm not about
kind of where we are.
There's no, we can't, that'll create nothing but
peace.
turmoil.
I get it, but
so the question is, as I determined that I think we have the authority to reconsider. I think that any appeal period would stem from final decision back in December. I think that it's possible to reword and reconsider this particular finding or condition, and I would propose the following, and then leave it up for discussion, that the applicant shall provide an easement only, not pave anything, not do anything, but an easement for pedestrian and bicycle access to the right-of-way of Colony Drive, the exact location to be determined by the Department of Planning and Zoning. So it's all that it does is it leaves on paper an easement, nothing gets done, and everything stays the same. But if in the future there are changes of heart and perspective, that easement then can be taken advantage of. Okay? Given that, any questions about the wording?
Well, just to clarify something, I just want to say, so basically they're still going to have they're still going to have their bike path and everything. They're just not going to have a little spur off of it.
Yes.
But the easement will still be there.
Yes.
Just in case we have to. I have to say that, when Mr. DeQuiznio, I guess I'm looking at Mr. DeQuiznio is actually the one that made this motion, although I know it was a lot of you, Alex. But the part of being on Planning Commission is that we have to plan, and we're planning for the future. So I see that we did nothing wrong here, that we have to, keep that in consideration, that planning is part of planning, and that's our job. It's not just to rubber stamp things. So we have to keep that in mind, that if we can do this, it's not because we did anything wrong, it's because we're just tweaking it a little bit.
Can I just add something? If you read number 22 again, it doesn't say access into...
It doesn't say easement.
It doesn't say access into the right-of-way of Colony Drive. It doesn't say access into that community. It doesn't say anything that goes over the line of where Central Park is.
Right.
It just says to.
Right. It doesn't say easement either.
And it doesn't say easement. So in a way, I think the way I see it here is that if you read this literally, which you should, it just says to. It could have said up to. It could have said not into the Colony Drive community. But the language here only says to the right of way. So I'm not sure that anything needs to change.
All right, let me ask another question along that line.
Yeah.
If the language says applicant shall provide for a paved spur, what does that mean, provide for? Does that mean he actually has to pave it?
Or money in a pot?
It means whatever the Department of Planning and Zoning wants it to mean, because they're the final arbiter of where it goes, the exact location to be determined. And I think at some point, the Planning Commission turns it back over to the department to implement.
Okay, I might ask Dr. Nance.
I'm going to say, Gary, that says the Planning and Zoning Department will determine final location.
I understand.
Location.
I understand that, but
I'm a little bit concerned, to be honest with you, that we don't want, the Planning and Zoning Department doesn't want to broker some agreement between the neighborhood and the applicant as to what this means, because there's also lots of problems with that.
Yeah. So what I can tell you is that, as Bob asked, and it's a good question, what does provide mean? Okay, it could be a dedication of an easement. It could be an actual easement on the plans or on the plat.
Right.
I'm sorry, and I think that the word provide can be, interpreted at least those two ways. So my feeling is that if it's left the way it is, it doesn't get into the Colony Drive neighborhood. The way the language is, just can you please hang in there a minute, okay? I mean, we do have to have, there's a protocol here for conducting public hearings.
It not only doesn't get into the Colony Hills neighborhood, it also doesn't upset the stability of the application and the position that it's in for the developer.
There you go.
That the other thing, so that actually if leaving it where it is and if the planning department is satisfied with providing for, and they interpret it to mean simply an easement on the plat, then that's fine.
Again, there's no width provided.
Okay.
It says pedestrian and bicycle path. That needs to be something that needs to be at least a minimum width of 3 feet. We're talking about a millimeter and all that kind of stuff. That's that's why I brought up. I don't. We don't want to get planning and zoning trying to broker some agreement with what's appropriate, and what's not appropriate.
When you talk about
planning
location,
commission added this.
When you talk about location, okay, location means you have to determine length and width, because the location, you can't determine the location without figuring length and width.
That is correct, but again, it's open to interpretation what that means right now, and there's been some differing opinions as to what that potentially means.
It's always going to be open to interpretation. If the language was changed to
no, it doesn't have to be. You can,
pedestrian and bike
specific.
Access, you would still be faced with what does that mean?
Okay, I'm just saying there's been some differing opinions, and planning and zoning has some concern about, defining that at this time, because there's some community members who support a path, some community members who don't support a path, and there isn't like one particular group or representative here. There's multiple people. So as far as dealing with there's no specific representative that represents the whole community. So
but to get back to practicalities, there's no necessity to get anything done now.
Well, you can't.
No, exactly.
Right.
And
except
simply if the easement is on the plat, it will remain as an easement, and nothing will get done until the time comes. And then, frankly, this is punting it down the road. Some other planning staff member will determine whether it's 3 feet or 3.5 feet, or not at all, or if there are bollards at the entrance, or whatever they decide later.
Well, they have to show the easement, or at least provide some dedication for an easement.
It can be a dedication.
It could be a dedication.
Upon request, it'll be conveyed. A dedication means conveyed upon request, right?
Sure.
Okay, so
that's fine. I just wanted to point out some problems.
Okay, I got you. I withdraw the motion. Because there's no need for it. There's no need for it.
Leaving it as is
Leaving it as is leaves it basically
makes
as
the
is.
developer happy. And how many easements do we have in the city that never get acted upon and haven't for the last 50, 100 years?
Countless.
There's one at the end of my street. There's two of them.
And there's a pedestrian and bike access at the end of your street.
That's
between
correct.
You and the Heritage neighborhood.
That's correct.
And it is less than 3 feet.
That's correct.
It's very tight, right? And you can't. It's configured in such a way that you can't get a motorbike through it. So these things can work if people work at it. All right. Enough said on that topic. Is there anybody else who has anything to add? So then the decision that really needs to be made is whether we reconsider this at all.
The applicant doesn't want it to be reopened and
The applicant
changed in any
doesn't?
way. I think that the applicant's view
I
is
think,
not to
I think it
change.
has been reconsidered, Bob. I think that's what we've been doing for the last several hours. But I think what you're asking is revise.
Excuse me?
I think that you're actually asking, does it need to be revised?
Does it need to be revised? And if so, can we, right. Does the Planning Commission wish to reconsider finding 22? I'm going to pose that question.
Given the discussion that we've been able to have, and I think that a broader understanding perhaps has been floated, that perhaps people now understand much more about the intent and what the condition imposes upon the applicant, and only upon the applicant. I would say that I'm not sure that there's anything to be gained by wordsmithing a further revision of condition 22. I think now it's abundantly clear, I hope, that what was intended.
And removal of this condition, I don't believe that the applicant wants removal of the condition. Is that correct?
That's correct.
And if we actually removed tried to, the applicant would have to agree. Is that correct, Mr. Attorney?
Well, I think under the best set of circumstances, that would be nice, but then it opens up some legal questions if you revise, as to what the consequences of that actually are. So if you're satisfied with the language, and the language adequately expresses the intent of the Planning Commission, then, and I think the intent has been pretty much discussed here, and it's clear what the intent is and what the effect of the language is. I think the language is clear that it's to the line of Colony Drive.
And it's only an easement at this point.
It could be an easement or a
doesn't say
dedication
it's
of an easement.
Or a dedication of an easement.
What if I said the language was too open and maybe the condition was not worthy of continuing as a condition?
Can you repeat that?
If the condition's wording is too open and they're not specific enough, therefore removal of the condition?
I think it's specific enough to withstand any legal argument that it's not. Certainly the location is left to the discretion of the department, and it's clear that it doesn't go beyond the line of Colony Drive. It only goes to the line.
And the words provide for are ample, leave
Yes.
ample room for simply dedicating an easement.
I totally agree with that.
And the Planning and Zoning Department would accept that, as well as the applicant. So those three things, I think, leave it sufficiently stable legally. Okay. Mr. Iams?
I think it's very clear what our intent was, and that there's a lot of fear, and it's understandable fear. I've seen things happen where people aren't paying attention, or people assume things, and next thing you know, it goes through, and people aren't addressed. But this is on the property. It has nothing. It's all contained within the Pastrana property, and there's nothing that says anything about cutting through a property. Nothing that, and there's a lot of obstacles that would need to be overcome to do that. They're pretty insurmountable obstacles, in my opinion, that I don't see any reason to open anything up to make it more confusing or to have any more heartache for the applicant on this issue at all.
Thank you. Mr. Pline? Do you have anything to say?
Only I'm glad, and I hope everybody understands the intent is not to put something, plow something through. It's just to have an easement if people mutually decide that that's what they want in the future.
Okay. Ms. Butler? Ms. Butler? Ms. Butler, please, we've done so well.
I wasn't here when this was originally discussed, so I didn't vote on it. But now that I've heard what the intent was and where this stands right now, I'd like the idea of reserving the property for some future potential connectivity. I think that's important for a lot of reasons. But it as David just said, it probably is going to be a battle when it does come up for consideration.
If it comes up. Yeah.
If it comes up. So it's it's something in the future. My main concern is that the surrounding homeowners have appropriate notice, and that they, are able to contribute to the discussion when that happens.
Okay. All right. My comments, I would like to start off by saying that I really very much appreciate everybody's patience in the last hour or so. Thank you. I mean, it really helped to carry this conversation to what I hope is a really acceptable conclusion, mainly that nothing changes. But I appreciate it. It really helps when we don't just jump up and make speeches, but we listen. As you can tell, we work very hard at what we do. We try to do the right thing. So I would like to call for a vote on whether we wish to reconsider. A yes vote will mean a vote to reconsider. A no vote will mean that there will be no change to the finding as it stands. All who wish to vote yes to reconsider, please say aye. All who vote no to reconsider, please say no.
No.
Please note that it's unanimous. So, after a very long discussion, I want to thank you all. I don't know. I would suggest that you direct your questions, of which there are certainly going to be some. Please direct them to Dr. Nash and Ms. Gudenius, and perhaps they can help you out. In the meantime, we have a lot more business to do tonight.
Thank you, Mr. Chairman. Thank you.
No good deed goes unpunished. Here we are trying to pedestrian connectivity.
All you hear is people that stood up there going nuts about it.
Well, they videotaped the whole thing. I don't care. I didn't say anything bad.
Couldn't make that.
We didn't say anything negative. I'm glad it was unanimous.
No, I really don't.
It's better to go through staff. We're the liaison to the planning commission, and we'll forward your emails to.
And this, while I have Mr. DeQuinzio in the neighborhood, would you keep July 8th open? Everybody here, I want you to keep July 8th open. We may attend to some recognition of the man's 14 and a half years of service on this commission, having...
On a Monday, no doubt.
And so the city council will present a citation, hopefully in the early part of their agenda, and then we considered maybe retiring for a dinner.
That's a great idea.
Keep it open. All right. Now we can get back to business.
All right, good evening. Sally Nash, Department of Planning and Zoning. I handed out one letter we received regarding this ordinance titled FAQs about neighborhood conservation zoning. This ordinance 01119 is to modify some of our procedures for demolitions in R2 and C. The R2NC Single-Family Residential Neighborhood Conservation District is primarily in the Eastport Peninsula, as shown in the map on the staff report in orange. The ordinance outlines a new process that would now require city staff to qualify and hire structural engineers when we have an application for demolition before us in R2NC. The applicant would pay for the structural engineer, but the contract would go through the city and be managed by city staff. So the interaction would occur between city staff and the structural engineer, not between the structural engineer and the applicant. The applicant, so again, though, the applicant would still be responsible for the cost of that expense. So in the R2NC district, there are additional development and demolition standards that apply above what we have in our other residential districts like R1, R2. And these, the purpose of these is to preserve patterns of design and development and ensure the preservation of a diversity of land uses together with the protection of buildings, structures, or areas the destruction or alteration of which would disrupt the existing scale and architectural character. So that's the most important part of the R2NC is maintaining the scale and the character of the neighborhood. Demolition in this district has a particular definition. It's defined as involving the entire removal of more than one exterior wall or the entire removal of a roof structure. That is what we consider demolition in R2NC. Currently, if a demolition is proposed and there's a question about the structural integrity of the structure, the Director of Planning and Zoning may require a structural analysis of the building by a registered structural engineer or architect to determine if the building is sound or not. There are other requirements that an applicant has to address if they're proposing demolition in R2NC. They're listed on the staff report. There's 4. One, that the loss of the structure would be adverse to R2NC. 2, the proposed demolition would affect the design and historic character of the surrounding environment. 3, that the demolition is not for assembling properties and then building something bigger. And 4, that the replacement structure is designed and sited in a fashion that reflects compatibility of the objectives of the R2NC district. So before we approve a demolition in R2NC, we actually basically have to approve what is going in its place. So, and that's different than a lot of other areas in the city. So this legislation changes the discretion of the Planning and Zoning Director to require structural analysis from may require to shall require. It also makes sure that if an applicant is proposing something less than a demolition, but the Planning and Zoning Director has concerns about whether that work will destabilize the whole structure, the applicant has to show that there's sufficiency of the load path for the proposed alteration. In other words, the alteration isn't going to cause a situation where later they're going to come back and say, oh, we have to demo the whole house because now it's structurally unsound, based on the work that they did just to do the alteration. Planning and zoning staff suggest one amendment to clarify the legislation, and that is that it's a little unclear in the legislation what happens if the structural engineer comes back and says the house is structurally sound. It's not clear if that means in no case then can we allow a demolition, or are there some criteria that we can use that we would allow a demolition even if the house is structurally sound, which is currently how we do it. If the house isn't considered contributing to the R2NC district and there would be no loss or adverse effect on the R2NC district to losing this particular house, then we sometimes allow demolition even if the house is structurally sound. And we aren't sure if this would still be allowed under this ordinance, or if this ordinance is intended to no longer allow demolition at all if the house is structurally sound. So we're a little unclear of that. We're also a little unclear on whether if the house is unsound, it's found to be unsound, then we pretty much allow the demolition because we consider that a matter of safety. It is unclear in this ordinance if we are still allowed to do that, because we say, oh, the house isn't structurally sound, you can demo it because otherwise it's going to fall down. If we're not 100% sure if that is still the procedure in this ordinance, so that would be nice to have some clarity on that. Again, the new process works similar to what we do for traffic studies. We would qualify people. We could hire them on a rotating basis, the structural engineers, and we work with them. They don't deal with the applicants, so there's no conflict of interest. So that part is pretty straightforward. Okay, any questions?
Is there a specific incidents or two in the recent past that's cause for this legislation to come forward? Like maybe somebody, let me guess, am I on the right path here? Is modified some home structures in Eastport and it's, or structurally demoed them because some of these things have happened where it's no longer structurally sound, and kind of work the system to get rid of it and then put up their new looking house, which is not really what we want? Is that, I know that's very broad.
I can let the alderman who introduced this legislation speak to the intent of the legislation and why he's bringing forward at this time.
Should I wait that time, or?
I have questions of staff. Are you done?
Yes, sir.
Well, you can always take it back later.
Right.
There's a demand on staff, an additional demand on staff to hire the structural engineers. How do you, now that you're in position of acting director of the whole department, how do you feel the department can handle the additional workload? And are there other things you'd rather be doing?
I can understand the concern about the conflict of interest. Mm-hmm. A lot of times there is a feeling that the structural engineer is representing the homeowner more than the concerns of the community and the integrity of the R2NC district.
Uh-huh.
I do have concerns about additional demands on staff time. We are very stretched. Current planning is very stretched right now. It's just one more thing on their plate. We would probably get assistance from the Chief of Code Enforcement to help us with this particular process, but there's a lot on his plate too. So that is a concern I have. After we have the RFQs done and we have a list of qualified professionals, it won't be as demanding on our time. It's really that first part of preparing the RFQ, qualifying firms, interviewing firms, contracting with firms, and figuring out how we work with them. That's really the part that's going to take the longest. But I can also let Tom Smith speak to impacts on staff as far as that concern goes. But that would be a concern I have.
Okay, I have further questions for you. Would you like to hand it over to Tom, or would you like to answer more questions?
Are they specific about the process that we follow reviewing applications for demolition?
I think so. I don't understand the business about load path. Now, is this legislation, if enacted, would it require, in cases of any partial demolition, that there be a structural analysis of the load path so that the remaining structure can handle the new construction? So, in other words, in partial demos, will a structural analysis be required?
The legislation says that in cases where approval of an application is dependent upon preserving all or part of an existing structure or building, if the structural integrity is in question, the Director of Planning and Zoning shall require a structural analysis of the structure or building to evaluate the sufficiency of the load path for a proposed alteration.
Well, that's unclear. If it's in question, and then you should require a structural analysis, and that's analysis, does it follow the same you choose and they pay path?
Correct.
Okay. So in any kind of partial demo, if anybody raises the issue about whether this is going to fall down or not, okay.
There would be some judgment required, if they're doing something very minor, it might be more obvious than if they're doing something bigger, but you're right, there is some discretion there about when the structural integrity might be in question.
Yeah. Okay, so there's a question. The legislation also adds building to homes. So in other words, all buildings, commercial, institutional, religious, fraternal, all buildings in which there could be any partial demolition, any question of structural integrity, and any total demolitions, right, all would have to follow this. As it stands now, buildings are not included. Is that right?
Well, right now it says structure, and it's adding structure or building.
What's the difference between a structure and a building?
I was hoping you would not ask me that.
Well, we can ask Mr. Smith that question.
Okay.
And finally, how does this compare to what's required in the historic district?
Well,
would you like to have
in the historic district, I'll take a stab at it. First of all, there's a list of structures that are considered contributing to the historic landmark district. Those are typically structures built before 1932, and they have certain characteristics. If you're contributing in the historic district, it is very hard to make major changes to your property. If you are not contributing, if it's a newer property, it's a little bit easier to make alterations provided you meet the Department of Interior Secretary standards, which are laid out in the guidelines to the historic district and are, pretty decent book size. All the criteria has to be addressed to the HPC's satisfaction before they'll allow alteration or demolition of a structure. They very rarely allow a demolition of a contributing structure. I don't know in a situation that they would, maybe if it was unsound or falling down or something like that. Eastport has evolved more over time. In the 2000s or late 90s, we put together some information to nominate it as a historic district, but there wasn't enough historic material intact to really qualify it. So we've kind of adopted this hybrid approach where we focus a lot more on scale and character and less on material itself when we're reviewing applications. So for us, the most important parts of the R2NC are really maintaining that scale, maintaining the look. But we don't really care if people use hardy plank or, wood. In the historic district, you can't use hardy plank no matter how nice it looks. You have to use wood or original materials. So those are the main differences. I don't know, Tom, do you want to add anything?
So the matter of demolitions in the historic district is really covered by the historic preservation standards, which don't apply across the road.
Right.
Okay. I think those are the questions.
I had a couple questions. How many structures would this apply to in the R2NC district?
Well, all structures larger than 120 square feet have to be site. Larger than 120 square feet have to go through site design.
So I've been told that that's something like 800 structures.
That sounds like a good number, although I don't know for sure off the top of my head.
Okay, that seems like a lot to me. And then the question is standing. You said, going back to the process of questioning why a structure on that, is the building structurally sound? Mm-hmm. It's one thing if you ask that question. It's one thing if Tom asks that question. But it's another thing if I ask that question. I have no standing. I have no knowledge or, I'm just the man on the street walking past. Is there some qualification or can just anybody say, hey, you got to do a structural analysis of that building? Or do you in fact have to have some standing to do that?
The ordinance is clear if it is a case where they are asking for a demolition. The ordinance does not really speak to who may question the structural integrity of a structure if a alteration is proposed.
So that's wide open.
We seek public comment from anyone who gives us public comment. We would have to evaluate it on a case-by-case basis, but I imagine if there was enough concern and there was, specific evidence that was illustrated to indicate that there could be a question there, it might be enough for us to require a structural engineer to look at the property.
That seems pretty squishy to me, but okay.
Well, we are happy to have more black and white if you want to offer an amendment about in what
no, I'm
particular
just trying to
get
to the root of why is this coming forward and for what purpose?
I certainly wouldn't want to get in a situation where we didn't require a structural analysis and then the house then falls down and then people are kind of saying, why didn't you require a structural analysis? And we thought, well, we didn't realize it was, it might be nice to have more if A then B kind of language in this part of the ordinance.
So can I try again with even a more simple question than Mr. Sale asked? Just what problem is this trying to solve? I read through this and it's a lot of language and it's a lot of stuff, but I have some suspicions, but I just don't. I'd like a really simple statement as what problem is this solving?
First is the perceived conflict of interest with the structural engineers and who they represent. The second is whether people honestly or what did you say, sneakily attempt to go around our rather difficult demolition requirements by doing a little bit at a time and then, oops, we've accidentally made it so the structure isn't sound and we have to tear it down and do what we wanted to do all along.
And that happens a lot?
Actually, I'd like to say from my experience in Eastport, I have a house across the street from me that they're trying to, one could argue that it's going to be demolition by neglect. So they open all the windows throughout the winter and spring, and I had to call recently to say there's a raccoon or a cat living on the third floor that goes in and out from the roof that I face. My bedroom looks over it. So yes, people try to demolish by neglect. And this isn't addressed demolition by neglect is not really addressed in this statute, but yeah, I think, I'm sure Alderman Arnett will have some examples for us, but I think that's part of the...
I'll say that our regulations in R2NC are very restrictive, and that sometimes prevents people from being able to do what they want to do.
So in this case, do you find that somebody hires a structural engineer that responds to their customer's will, saying, "Oh yeah, it's unsafe"? So you basically buy somebody to say what you want. Is that what's happening?
That is the rumor I hear. I mean, obviously the person is a certified professional, so they are putting their reputation and livelihood at risk by doing that. But that is the feeling in the community is that happens.
Sally, we independently addressed demolition by neglect within the last 12 months, right?
That was for the historic district.
Yeah, it's only for historic district.
Okay.
Right, but they're doing it in Eastport, but you're right, it's not being addressed here.
If demolition by neglect is in fact the problem, then we have a tool in place that could be easily modified to, or extended to address it.
So let me ask a follow-up. If, let's make the assumption that it's being used for less than honorable reasons, is there not enough in the regulations in the NC that allowed people to do something that's contrary to the mass and scale? I mean, it seems like if they tear something down and build something new that's not appropriate, that should be addressed maybe through the regulations that determine what can be built versus saying you can't tear it down. I mean, let's for the sake of argument say that you want to tear your house down because you want a very different interior layout, and there's really no way you can do it without tearing it down. So you tear it down, but you rebuild the exact same external dimension that's acceptable. It seems like governing what I'm sort of like side loading in a form-based kind of idea here, but if what you're really concerned with is what's being built, and that people are using this to get something built that people don't want built, you're addressing the wrong problem, I guess is
So, welcome to every staff debate we have about R2NC. So there is a bit, since it's not a historic district, we can't really be as stringent. However, I think it is still very important to staff to first conserve what we have, if it is all possible, feasible, or desired. I think that is our first impulse, to really protect what we have. But a lot of times it ends up, yes, they tear everything out, but some 4x4s, rebuild it. What do we really have, by the end of the day, compared to what we started with? But that being said, our first impulse is to protect and conserve. It doesn't always work out in the messy way of making sausages that is reviewing R2NC property, but that is our goal. That is something we try to do consistently when we can. But it is tricky because we don't have the same regulatory framework as we have in the historic district. So we're trying to always juggle different goals of the R2NC district that sometimes honestly conflict with each other. This tendency to protect and conserve and this tendency to maintain scale and character, they can conflict. So it's just us trying to feel our way best we can. But that is why we have this issue.
Can I give you like an example of that may help you evaluate this ordinance, proposed ordinance. About 5 years ago, the Board of Appeals had a case, 518 Burnside. Tom was involved in it. I know Ross knows very well about it. And it was a very, it was not in the historic district, obviously, and it was not, there was a debate over the historic significance of the house. The house was built, as I recall, in about 1905. Board of Appeals did a site visit to the house in the middle of the in the middle of proceedings, and there was a structural engineer who the homeowner hired, and the structural engineer came in and said what needed to be done in the house, and that it was more expensive to do that work than to just tear the house down and redo it. At any rate, what happened in that case is that the Board of Appeals denied the demolition of that house. There were all types of things that were at play there, but one of them was the historic significance of the house, and the other one was whether the structural problems of the house could be repaired, and so that the house wouldn't have to be demoed. And so the applicant, the homeowner, argued that it was going to cost $200,000 more to fix it up, make it code compliant, than to just tear it down and rebuild. And they were claiming financial hardship, which is one of the things not in the R2NC standards that you have to evaluate, but in the standards in 2114, which is a different section of the code, which are applicable to any district where demolitions have to be approved. And the argument was not accepted about the $200,000 difference because the board found that the house could be made structurally sound, even though it would cost more money. That wasn't enough of financial hardship to warrant bringing that house, a house with historic significance, down. And so, in that case, we had a structural engineer hired by the applicant who was making the applicant's case. As Sally said, that I'm sure that structural engineer, whoever it was totally professional, totally reliable person, but testimony wasn't accepted. It's better to have an impartial third-person structural engineer to evaluate these things to help the board, in this case it would be the Board of Appeals, make the decision. Because, one of the things the board struggled with was, is the house really structurally unsafe, or is it so structurally in disrepair, that it has to come down?
Gary, isn't that situation with the structural engineer being hired by the applicant, isn't that analogous to our traffic engineering problem that we've had historically and frequently in this body, and hasn't the department in recent years made important policy changes to separate the hiring of the expert from whoever pays the expert? I submit that that's a different problem. That's a very soluble problem because we've got ways we've done it in the past, and I don't know that that should force us into some greater action or more restrictive way of operating.
Well, right now, I don't know when the change was made, if there was a change made, but right now it would be the same. The traffic engineer is hired by the city, and but the applicant pays the bill for the traffic engineer, so it would be the same thing. And it works. I think it works.
It seems like it works better since we went to that system.
Yeah.
So I can understand that would be a concern and we'd want to address it, but I'm not sure that it has to be addressed in this particular fashion.
Anyway, I was just trying to give you an example where the structural engineer's analysis came into play in a case where it was, it was an important part of that case.
I think I'd like to ask Tom to come up and just say a few words about the process itself of when we review applications.
So can I just mention one thing before you go? So what you said really, I don't see anywhere in here. So you basically said the intent is protection and conservation of what we have is really the intent, and I don't really see that in the purposes include.
Can we need to
so-
keep moving along here tonight, so let's try to keep moving, okay? Mr. Smith?
Something to think about.
We need to think, we need to keep moving here, we need to get our questions sharper. You were going to turn it over to...
Unless you've got something specific, Mr. Chairman, in the case that Gary mentioned earlier on Burnside Street, that particular structure was perhaps one of the finest, if not the finest example of a Queen Anne structure in Eastport, probably the second house built on that block, and thus removing it would begin to change the character of the neighborhood, regardless of what you put back, even if it met the R2NC guidelines, which it would have to. So yes, preserving of existing structures is preserving the character of the neighborhood. So we work very hard and very diligently to do so. And we have had on more than one occasion structural analysis submitted that did not say that the structure was unsound and unsafe, and we said no. The applicant then hired a second structural engineer, which said something different. And we're not structural engineers, and thus we're sort of forced to then accept that second structural analysis. So hopefully this helps out in that.
So you're comfortable with having to compile the list and going through this?
Yes.
Okay. I have a question. Dr. Nash mentioned, even in her report, that it's unclear whether in the case of a sound structure, whether any kind of demolition would be prohibited. That the legislation is unclear. Do you know what part of it she's talking about?
We had the same question. We staff collectively had that question when we read what was being proposed, and we'd like to have some additional clarity.
Do you know where in this proposal where it is that the clarity could be? Where's the confusion?
Sorry, Mr. Chairman.
And keep going. While she's looking,
yes,
this legislation applies to all alterations, everything. It applies to additions and any alteration to the outside?
Well, the R2NC, yes. If you're going to alter a structure in the R2NC, yes.
What if you want to put in a bay window in the back?
Yes. I mean, it
may
not go through... No, not structural engineer. When you said process, I misunderstood. I thought you meant the design review in an R2NC. I'm sorry.
So even in the case of, like, you're taking off the back of a small house and you're putting an addition on, and you have an architect prepare the plans, you have to have a structural analysis done by somebody else as well?
Well, I think that's why there is some discretion in what's being proposed here as to...
Only if there's the question of it's sufficiently stable.
Correct. Typically, if you have an architect involved sealing plans, yes, you have some degree of surety. However, we have had structures for partial demolitions, and they have come back and had to be torn down completely.
Because?
Because they frankly weren't protected correctly, and that the structures weren't as stable as we were told they were originally. So we have one partial demolition case in Eastport right now where we actually have required them to do a structural analysis on a partial demolition to make sure that the part of the structure that's being preserved can be preserved.
Okay. I'm getting a better feel for what the legislation does and doesn't do. Okay. Are there any other questions? Well, where would the clarification come? How would it come? Do you want to wait on that while we move forward?
Thank you.
I'm going to open the public hearing. I'd like to hear testimony from anybody who wishes to testify in this. I understand. I happen to see Alderman Arnett, and I believe his name is on this bill. So he may have something to say about it.
Ross Arnett, 529 6th Street, Alderman, Ward 8. I was patting myself on the back because I thought this was going to be a lot simpler than your previous thing, but we're growing in our concerns. So I want to speak initially to the questions you were asking, Alex. It's a conservation district. It's not a regular R2 district. And I think Dr. Nash gave you all a very good, much better than I can do, explanation of the legislation. Tom and Gary have told you about some of the problems we've had with the demolition. There's the concern that if the applicant is hiring the engineer is going to favor the applicant. If the city is hiring it and we have a rotating group of people like we do on the traffic study legislation, that there's less likely to be that kind of concern. 518 was a great example, and it spoke to the very thing that you were concerned about, Alex. It's my favorite house in all of Eastport, and it's a block away from me. But the owner wanted to take it down and put in a Southwest style hacienda, one story with a little enclosed patio and those sorts of things. Well, there actually is a house somewhat like that on 5th Street across from the school, the elementary school, but really not what we consider characteristic of the Eastport community. The irony is they were claiming that it was more expensive to tear it down and build new because there were all of these problems with the structure. However, it is being rented under a long-term rental agreement and is inspected by the city every year and passes inspection. So I don't know how structurally terrible or out of compliance the building can be if it's legally rented, but in any event. So because we're not under historic preservation legislation, we're a conservation district, and it's kind of amorphous and squishy and probably drives the staff more crazy than almost anything else, maybe other than Crystal Spring in the city. It is problematic, and it's always touchy-feely. You can't just go and say, here's what the federal government regulations say, these are the things you have to do. And because we need to be sensitive also to the rights of property owners. So we can't be dogmatic about it because we don't have the federal code, and we do need to be sensitive. So there's a lot of projects. There's one right now, 405 Chesapeake Avenue, where they're taking a very small house and they're putting a huge addition on the back. It meets the definition of demolition because you're taking out more than one wall. I don't think they're doing, I think they are changing the roof, but I don't know if they're taking the whole roof off. But anyway, this happens all the time in Eastport, and it's a constant balancing act to figure out what we can do to accommodate the needs of modern people who seem to need to have several bathrooms in the house and several big closets and so forth, versus conserving what the community looks like. And the desire from the Conservation District was that we don't want to see everything McMansionized and the whole community change. Now, there's a very good natural experiment going on in Eastport because you can look just outside of the Conservation District, not the Historic District, on like Washington Avenue and places just outside. And in fact, I think the buildings are not being McMansionized, but they tend to be the more gingerbready, the arts and craft style homes rather than ones that were there originally. So there's no doubt if we didn't have the conservation legislation that while we might not get the McMansionization of the community, we would definitely have a change in the character. It happens that 518 is a Victorian farmhouse structure. It's probably the predominant kind of structure in Eastport. There's a lot of four squares. My house happens to be a Tudor cottagey kind of house, as the one next to me, and there are a few others in the community. But what we're trying to do is to get the, oh, is it getting late? Get the scale of the community. So the one thing that Sally touched on that I think is a really important thing is if the building is a contributing structure. We started under Lisa Craig defining contributing structure, and there are buildings that are newer buildings. I think 1951 was the cutoff period. We said if it's built before 51, it's automatically contributing after that. So I do think we need some clarification in this. I'm certainly open to whatever the suggestions are from the commission or the staff. Your question, Bob, about building versus structure, you need to ask Gary. He's the one that put that in.
What he told me is that it's simply becoming consistent with everywhere else in the code, which says everywhere you go, buildings or structures.
Yeah.
So
And there are two different definitions in 2172.
there are different. Structure includes building, so there's not. But that's the least of that's the least issue.
In terms of Bill's question, I don't think we've ever had an instance of somebody walking down the street and saying that house doesn't. Maybe Rick Gamble's house, but this is when people apply, and they're applying to want to change the structure in the conservation district. So that's when they fall under these rules. It's not a general rule of inspecting houses in the neighborhood. So that's sort of the overview. I don't know if you have any questions. I think Dr. Nash did a great job of explaining to you the legislation, and I think Tom gave you an understanding of what happens if you don't get the rendering from a structural architect you want to let you do what you want. You shop it to another and to another, and I don't think that happens often, but I think this legislation would be good to make sure that it doesn't happen, the staff. As far as the staff, I'm in total agreement that the staff is overworked and they need more staff, and I've had that position for several budgets, and I think that's a legitimate concern. But I would hope once we set up this pool like we did for the traffic engineers, it would just be a matter of assigning whoever's the next one up and have them do that. So I hope it's not too onerous. But you can complain to me if it is tough.
Ross, I had a question.
Yeah.
Among the things you said, you cited, and I've heard you say it in the past, you talk about the McMansioning of Eastport, and I know that's a concern. But my question is, how do we get to preventing the McMansioning of Eastport by requiring people to do a structural analysis of the structure? It seems as though that's kind of going three ways around the block in order to get from A to B. Why not put the effort into defining design guidelines that will stand up in court rather than simply trying to torpedo people's plans from below the surface?
So let's take that. How do you McMansionize? Suppose I wanted to take my house, 1,700 square feet, and put in something that's 4,000 square feet. I can't do it with the house still there. I might be able to graft something onto the back of the house, and in fact we explored it, but at some point if you want to McMansionize, you're going to have to tear off part of the house and graft the new addition to it. That's what's happening at 405 Chesapeake Avenue.
But isn't that a function of things? We have an existing legislation on lot coverage. Isn't that a function of things like setbacks? Isn't that things that we already have those levers and dials and controls built into how we regulate development? I don't know that going into requiring kind of structural analysis really gets to that.
Well, the structural analysis is used by the applicant to justify the removal. It's not the city that's...
Okay, so it's strictly a kind of an initial casualty of the process in terms of to get rid of the old building.
And the load path, it was actually new to me, but it is the case. In fact, for 214, Chesapeake was something that was initially a partial demolition, and then they got in, they found termite damage, and it ended up being a total demolition. In that case, it was a house that was being built back in kind with a wing added onto it. So you really couldn't tell the new house from the old house, but the structural, you can get in and nibble away and make it unsound and have to tear it all down. I think 600 6th Street had that as well. Gary Swersler did. So the load path thing is an important enhancement to this legislation, in my view.
I have a problem with reading in the language here.
Okay.
This is on page 3, demolitions 3. Well, it's not numbered right. It should be capital A. It's B. This is an addition.
Are you're saying 3C?
3B, page
B.
3.
The bold, okay.
Demolitions. New language. Before the director may approve a request for a proposed demolition, there shall be a structural analysis, period. Okay? To evaluate the sufficiency of the load path. Okay, so let me see if I understand this. If it doesn't say what kind of demolition.
Well, the demolition is defined in code. It's removal of more than one wall or removal of the roof. So if it's a demolition, then it automatically comes to
Well, it
this
doesn't make any sense. It doesn't apply to full total demolitions. It only applies to partials.
Well, no, it applies to partial or total demolition.
All right, so if it applies to total demolitions, there has to be a structural analysis? Why? If it's permitted, if it's not going to change the character, if it complies with all the other factors.
The analysis justifies the demolition. The analysis by the engineer says this house is so structurally unsound that it can't remain standing. It's a danger to life, or health, or safety. So the engineer gets involved to justify the demolition. And the justification is the structure is beyond saving. And they
Okay.
go through a number of reasons why.
Okay. Okay. I don't know why this was. Any other questions?
I also take it that this is targeted at stopping people from demoing one wall and then saying, "Oh my gosh, it's unstable now, so we must demo the whole thing."
Yes.
To stop that as well.
Yeah,
Clearly.
well, that's part of it. You can demo one wall, but you can't demo one wall and any portion of the next wall. Would they do?
Okay.
But if you, in our hope in making this, would stop somebody from demoing a wall and or one wall plus something, and then making it, hopefully our structural engineering analysis for that
Well,
would tell us,
they
hey, if
can't-
that happens, it's going to be structurally unsound, therefore we would stop the
They can't
demolition
demo
application.
anything without coming in and applying for site design review and getting a permit. But you're right, if they come in and do one and then come in and do more, but I think they'd be found out pretty quickly on that.
Is it also safe to say that from your purpose that you give on this in your comments, what we've talked about a lot of things that we want to correct over there in Eastport, but this really only addresses one little thing of all these things we've been talking about that need correction, which is the structural supposed impartiality of the structural engineer. Instead of being hired by the applicant, it's now hired by the city, paid for by the applicant, therefore being a third-party impartial, really partial to the city. That's really all this corrects?
I think it does a little bit more than that, but that was the intent.
Yeah.
I mean, this load path and those sorts of things and some of the other wording changes
Right.
that came along with it. But the intent was to do these kinds of inspections the same way we do traffic studies. As far as the purpose section here, and I heard someone else, that's the purpose of this legislation. It's not the purpose of the R2NC. The purpose of the R2&C is much broader, and that's in the code.
Got it. And if anybody could give me a rough guesstimate of a structural analysis on a small, typical Eastport type home, are we talking 30,000? Are we talking 100,000 plus? I mean, I would think in the ballpark, you're under 50 grand for a structural analysis of some small residential structure. Well under that.
I think it's
Because there's the economic burden upon the
16,170.
applicants now to think of. What was it?
$16,172.
There you go. That's a great number. But significantly less than 50 grand is my point. So, from what I know.
All right, anything further? Anybody else? Thank you.
Thank you.
Hello, my name is Jackie Wells. I live at 201 Severn Avenue in Eastport. I just wanted to bring a perspective from somebody who similarly reviews applications, but who's outside of planning and zoning. I've been a member of the Eastport Civic Association's Architectural and Zoning Committee for about 13 years now. And what happens often is that planning and zoning posts the applications for public comment, but they send over the application packet to the Architecture and Zoning Committee for us to review and give comments back to planning and zoning. And they're just comments. We don't have a regulatory role or any decision-making ability. But after 13 years, I've seen a lot of applications, which is everything from somebody just adding a small bump out on their house to proposing a total or a partial demolition on their house. And one of the things that we have learned through our process, and we look to the application that is sent to us by planning and zoning, are the requirements to be able to demolish. And one of those is a structural analysis being done if the house is unsafe and unsound. I'm shortening it, but those are the key words. We look for the report by the structural engineer that's already required right now under the current code, but it's the structural engineer hired by the applicant. And we've seen lots of reports. Some of them will out and out say, we've looked at this house and it's, the walls are coming down the floor, foundations aren't there, to justify that this house should be demolished or partially demolished if that's what they're trying to do. But in many cases, there's an older house and they want to eliminate the old house and put up a whole new structure. But what we see in the report by the structural engineer is what I consider soft language. They won't have unsafe and unsound in there. They'll just say, well, the foundations aren't great. Some of the floors are drooping a little bit. The windows are old, and I'm like, yeah, that's the definition of an old house in Eastport. And in the R2&C, which is supposed to be a district where old houses, not new ones, but old houses are preserved if they can be, they can be added onto, but the original house should be preserved. We find that language pretty soft, and we'll comment back on it, and I know planning and zoning will push back on that language. But it's always a tough balancing act between the vendor, the structural engineer who's hired by the applicant who wants to demolish the house, to give the report that their client wants versus a real true report that properly assesses the structural integrity of the proposed demolition or house. So I think and support the idea of shifting and the client relationship from the applicant to the city, just like you've done with the traffic engineers, is a good move because it helps somewhat, at least, with, I think, the inherent conflict of interest that can arise when you're trying to satisfy your client. So I support, giving a stronger basis for planning and zoning to rely upon when they make their decision. Thank you. Yes, Jackie Wells. I'm the other Jackie Wells. There's another one that appears here a lot. Pardon?
Did you sign in?
Oh, I'm sorry.
It helps us keep the names.
Yep, I got it.
Anybody else?
Good evening, members of the commission. Dave DeQuinzio, 541 2nd Street, Eastport. Speaking only for myself tonight, not as a member of any organization. Have a couple of comments. I'd like to begin, number one, by commending you all for hanging tough into a very difficult situation earlier this evening. I know it wasn't easy. Next, I strongly encourage everyone in this room and everyone in the city, for that matter, if they learn of or become aware of a situation where a registered professional engineer in the state of Maryland has shopped a result, to report that immediately to the Board of Professional Engineers. That is, as Mr. Sale will back me up, grounds for either suspension or permanent revocation of registration in the state. And in every state in our nation, boards can and do take action in those situations. Sometimes it's a suspension, and the licensee has to take an ethics course or satisfy some other requirements in order to have their status restored. But sometimes they go further and they permanently revoke a license. And then it gets reported to the other states where that engineer is registered. So please do not stand for that. It is not a practice that should ever be tolerated anywhere under any circumstances. Now that said, it's also true in the practice of engineering that if you retain me or any other engineer to look at a building, now in my case you would not retain me for structural. I'm not a structural engineer, but in prior occupations, I was often called upon to assess the condition of mechanical and electrical systems, but the same principle applies. You have to be clear with the client to what standard are you making the assessment. So structural, you can do a structural assessment under different sets of requirements. A structure built in 1905 was likely not designed to support loads that a structure designed in 2019 would be. So clarity has to be brought to the question of to what standard is a structure being evaluated. So for that and other reasons, this concept could be a trip down the rabbit hole. So at this juncture, Tammy, I would suggest that you put me as in opposition to this proposed legislation. Now, that's because I am skeptical, not cynical. A skeptic can be, when shown evidence, may come around and change his or her mind. And I'm open to this becoming something I could support, but as it stands now, no, I can't. I also want to point out, I wish lots of things in life, despite its flaws, despite its difficulties possibly that may arise in its administration, I wish a lot of things in life worked as well as R2NC has in Eastport. I walk the streets of Eastport, I walk my dogs, and I say thanks to the heavens that we found the neighborhood and were able to get in at the time that we did. The preservation of its character is very effective, and whenever we have visitors, they say, "What a outstanding, what a great neighborhood this is." So actually, hats off to staff for administering it well. So let's be careful about tinkering with something that's working pretty darn well. Now, there could be disagreements about should this project have gone forward in the way it did or not. That can happen. But by and large, R2NC, I believe, is working quite well. I also urge caution when using terms like McMansion. McMansion is a very, some people describe it as a pejorative term, but in the years since it was coined and that I've heard it used, I've heard about as many different meanings of the term as I've heard people using it. I would argue that size alone does not make for a McMansion. McMansion, I would argue, is a set of design and placement characteristics. To me, a McMansion is on a former cornfield with no trees, very little in the way of landscaping. A McMansion has a lot of focus on its design on the facade facing the street and very little. So you may have a brick facade and very cheap vinyl siding on the other sides of the building or on the structure. And a McMansion may also have a design feature like the quote-unquote lawyer foyer. I don't think we have any of those in Eastport. Also,
Lawyers or foyers?
lawyer foyers. These, two-story structures, elements that just real estate agents like them because potential buyers go in and say, "Wow, that's cool." But we have large homes in Eastport that, by virtue of the quality of their design, do not, in my view, constitute McMansions because of the quality of their design. Their interaction with the streetscape is very soundly, smartly, thoughtfully put together in a way that when you walk past them, you don't feel dominated by them or that the neighborhood has been cheapened by them. So I would echo what Commissioner Harold said, that, or whoever had said, is this a solution in search of a problem? I don't see how this accomplishes anything. If structural engineers are misbehaving, report them. Let's continue the good work that is producing good designs that make Eastport a great place. Thank you.
So I have a question. Is your opposition based on the absence of standards and the vagueness of a, quote, structural analysis? Is that the basis of your objection?
The basis of my objection is I believe it is too intrusive to the property owner, that a property owner who's willing to come to the table and work with staff and adopt a good set of designs and design thoughtfully in accordance, in character and in a respectful way to the neighbors on the street, etc. I'm not sure that a 90-year-old piece of wood is so important to preserve.
Okay.
What's more important to preserve is the character of the design, and that character can evolve over time a little bit, but it's preservation of the character. I'm not sure that preservation of the structure is worth all that much. And if the idea of preserving existing structures, if that's thought of as a sustainability initiative, there are ways to address that. Sometimes keeping
Can I interrupt?
structure,
I want to ask a question. You mentioned standards, okay? That there are no standards here, and there are very various levels of standards which you can contract for, right? I want an analysis of this or that or the other. Okay, is that if I'm reading you correctly?
Yes. In other words, as an engineer, you've got to give me a set of requirements. You've got to give me a set of performance criteria so I can go analyze something and say, well, this engineered system, whether it's whatever kind of system it is, performs to those requirements.
I understand. Okay.
That may be why some of these structural engineering reports aren't satisfying anybody, because a set of criteria wasn't given to them.
And that's why you can't report them.
Right.
So that's why a set of standards needs to be clarified here. To what standard? I assume that you're willing to work with Mr. Arnett in order to perhaps make those amendments later.
Sure.
Okay. Thank you. Because I think there might be something to that. I'm not sure. I'm not an engineer. All right. Is there anybody else? The hour is beginning to darken.
Can I make a comment to Mr. Quinzio, please?
Yes, and then let's keep going.
While we have him up. What you referenced was the specificity to getting a structural engineer to be impartial to the city. Well, I really look at this legislation not just for that. I look at it more importantly as this is when the structural integrity is in question, it's not a may, but shall have the structural analysis done. And that being, the real question is the structural integrity. I mean, who's really making that decision prior to that? And do you think that this legislation still protects that portion of it? Instead of may, it's now a shall. So we make sure that structural integrity is proved by a structural engineer, and no matter who that engineer is, because that's the other part of this legislation. It's the shall. So structural engineering shall be done by the structural engineer to prove that the structure is integrity that's in question is actually no longer in question or is accommodated therefore. So it's almost like a stopgap measure. That's what this legislation does. So I can see it being positive for that. Do you agree or you still disagree with that? Clearly you'd like to think more on that.
Yeah, I'm still not sold that it's necessary.
Not sold on that part of it. Okay. Right. Because that's almost like what I see that the other value that this legislation provides.
Anything further? I'm going to close the public hearing. Dr. Nash, did you identify why you came to that conclusion in your findings or your report?
Well, the part I would like some clarification on in an amendment. So if you look on page 3 of the ordinance, 3B, you were asking about before, I think we would just like maybe one more sentence, if the structure is unsound, then what? Then they can demo it or not? If
the structure is
unsound, yes, then are they allowed to demo it in all cases? Or if the structure is not unsound, okay, so if the structure is sound, then are they not ever allowed to demo it, or can they demo it in certain situations?
Only if they comply with the other factors.
Okay.
All the NC2 factors.
Okay.
That's the way I read that.
Okay. But what about...
Because if it's unsound, it's unsound. It needs to come down.
Oh, no, but that's not true.
Yeah. Go ahead. Go with it.
I owned a building in West Annapolis, 14 Annapolis Street, that was, I think, called structurally unsound. And, we were tearing our hair out trying to figure out what we could do to make this building sound. And ultimately, one of the engineers said, well, you could do all this work and, put in entirely new supports for the rafters or the joists for the floors, or you could go to Home Depot and get some jack stands. And so guess what I did? I went to Home Depot, got 3 jack stands, put them in, and bingo, I'm structurally sound. So that example is simply that these things are gradations. It's not, black, white, black, white, black, white. You could be deemed structurally unsound for one flaw that could be repaired, to go back to the discussion that we had at the opening of this whole thing. So I don't know that we want to legislate, every finding of structural unsoundness leads to a demolition. I don't think that's what the author of the legislation would want to see anyway. And so I think we have to be very careful about going black or white.
Our objective should be structurally unsound. We want to make it structurally sound and keep the integrity of the neighborhood and what we have.
Right.
That's obviously what we all want.
But I think Mr. DeQuincio helped us understand that there are standards that need to be applied that are beyond our current understanding. So I'm going to say I would like to see us focus on fixing the 2 problems that I heard identified tonight. Problem number 1, demolition by neglect. We've got an existing model for the historic district that could easily be applied to R2 and C. And problem number 2 was, dementia is a terrible thing.
The standards? Standards for the analysis?
No, it just had to do with, had to do with hiring a structural engineer. I understand the hiring a structural engineer is embedded elsewhere in the code. We ought to do that the same way we do traffic engineers. Fix that problem and just divorce the client relationship from the person who wants to demolish the structure and build a brand new thing. That we have a cutout there the same way we do with traffic engineers. So those would be my suggestions.
On that second suggestion, I'm kind of with Mr. DeQuinzio. PE is certified by state boards and different states, and the way it's set up is a PE for Maryland, structural PE should not be different from a structural PE of Maryland by a different name. They should be the same, and you should trust their decisions. And if there's a bad decision, who are we to decide? Oh, you're a more acceptable PE than that one. Are we going to do it by a lottery? We really put ourselves in a position as a city. We're now choosing the PE for you out of this pool that's acceptable, but is there going to be some legal morass there? I'm kind of with Mr. DeQuinzio. You have a state board that makes these guys PEs.
Mr. Iams?
And will the city end up just going to the same people all the time that they,
Yeah, we would probably have 5 people we would rotate through. That's what we do for traffic.
But then you're really limiting at that point. Or you let it open for anybody who wants to bid
for traffic.
For it.
I'll just tell you how we did the traffic one. We put out an RFQ to everyone. Mm-hmm. Everyone was welcome to apply. Before, in the RFQ, we developed a series of qualifications we were looking for. They also had to submit their hourly rates.
I get it. Just like an RFP, and if they're qualified, they can be put on the list.
Exactly.
And you go through that list from one to bottom in the lottery, and you start whoever's going to be listed.
Exactly. Odds are, some people would fall out for not being qualified, and then we might start looking at cost as a way to eliminate some people if their costs were much higher than all the other.
But the point is, they work for Sally. They don't work for the developer,
and that's a lot more.
And that's helped a lot.
Ms. Butler?
If we could work out some more language to kind of make you feel more comfortable, or planning and zoning answer some of these questions, I'd be happy to do that. I'd be happy to work on the legislation a little more to clarify some of the questions you had.
What specifically do you think needs to be clarified?
The issue about whether, I don't think this, but Sally raised it, I think if a structure is unsound, sound, is there any, or were you trying to say, are other parts of the code applicable, like financial hardship would still apply and those other things?
Well, we don't have that in R2&C, but I guess what Bob's point was, okay, if a structure is sound, they still want to demo, then we go back to the purposes include on page 2 if these other conditions are met or not.
All in R2&C, not other parts of the code.
Right.
Okay.
It's in the R2&C. They still have to comply with the neighborhood character. The question arises.
So my question is, if it's sound or if it's unsound, then do we want to restore this language on page 3 that's been struck out about if it's a threat to public health and safety? Because as Bill mentioned, there's times a structure is unsound, but it is not a threat to public health and safety. And maybe we want to differentiate these situations where there is a threat and there's not a threat. And so we could restore that language that's there now in 7, or Roman numeral 7.
Any structure that's unsound is inevitably a slight threat to public health and safety.
So I think what you're saying is the problem is in this paragraph 3B. Is that right? Is that the problem?
Yes, and maybe the solution is in 7 above that, or maybe the solution is in finding these performance requirements that we would use to evaluate a structure. Maybe we need more of a matrix kind of situation rather than a binary kind of situation.
Well, I think it's in 3B. So what it says here is the director may approve the demolition, which includes totals and partials. he should require structural analysis to determine the sufficiency of the load path. But you want to add also to determine it's health and safety to the surrounding, to the surrounding neighborhood. Well, I can't remember the language. No? Yes? If I got this wrong?
If you look above in 7, it says determine if it is sound and not a threat to public health and safety.
Okay, can I add something?
Where is 7?
Right here.
Just right above
here,
3.
above it. But in discussing this with Pete Gutwald, Pete is the one who suggested that he would be able to more, it would be, he was looking in terms of what is enforceable and what is not.
Mm-hmm.
His concern was that threat to public health and safety was a very subjective standard that is hard to define.
Mm-hmm.
The load path language he felt much more comfortable with because he felt that he could more easily determine the sufficiency of the load path because it's more of an objective analysis rather than the subjectivity that goes
I think
into
that language is good. I just am looking for a little more guidance on the consequence of the structural analysis, I guess.
Does it come down to you just wanting to determine, if it passes the structural analysis test, can they still demo it? Is that what your concern is?
Well, I think that is
But there isn't a test. That's the point that Dave was trying to make. There isn't a box. You check, 13 boxes and you're good. That's the problem.
But I assume there's some type of standards that structural engineers would follow.
National building codes, yes.
Yeah.
Well, state building codes. And
against current code, 99.9% of the structures in Annapolis would not meet current code. That's absolutely the case. And we have buildings in Eastport, Ross, that go back 100 years. My building in West Annapolis was clearly...
It's not only sound buildings, but it's also buildings which some report says are unsound but can be repaired.
Yes, and if you say that applied to the code at the time, well, there wasn't a code at the time in a lot of cases.
Okay, we have, what I'm going to propose is that we need to come to a decision here. We need to decide what to recommend to the city council, and I think in the course of that, we need to simply point out what we think are the weak spots and may require some work, okay? With that in mind, if you don't mind, I'm making a motion that we recommend approval and that we caution the city council that they need to look at the standards which will apply to the structural analyses, okay? And they need to answer the question, what happens with sound buildings, although I think I've answered that question, and also what happens with unsound but repairable buildings. Okay? Have I covered the bases?
Mm-hmm.
Okay. Do I hear a second?
Second.
Any discussion?
Any unsound, this is not going to change it, but any unsound structure with enough money can be modified to...
I understand that.
So
I
that's
totally
covered
understand that, but we're not going to come to a decision tonight because it's not the right forum for us to come to that decision. Okay?
And there's a lot of...
That's a problem that city council needs to address before they pass the legislation. I totally agree.
Gotcha. And there's a lot of goodness in changing things in the code in here already, other than the big ticket items.
Well,
so there's a lot of little goodness in here.
We have a second. Is there any, and more discussion, do we have a consensus that it's a good idea to have the engineer hired by the city? That's the big ticket item.
I don't find an issue with that. That's just another list they're going to make of.
So that in our recommendation, we applaud that movement, but we also caution them that it needs to be defined what an unsound but repairable building, what that means and how far you can push somebody. I'm sorry.
It's fine.
Okay. Any further discussion? All in favor of that motion of recommendation, please say aye.
Aye.
Are there any nays? Okay. Nay. I'm going to assign a nay.
Yeah, I was going to say, I don't know if this is appropriate in the discussion piece, but I just don't think it's quite ready to come out of the oven yet. And so I agree with the basic idea of the conflict of interest in the
The
structural.
vote has been taken. Did you vote no?
No, I voted no.
Okay,
I
that's
wanted-
fine.
and I
But
wanted-
the time
I just
for
wanted to say
discussion is
why.
passed.
Okay,
We've
well,
got to
I just
move.
wanted to say why.
Okay, the findings are going to be assigned to who volunteers? Then they'll be assigned. Mr. Harold? Okay. Thank you.
I'll work with you. I'll work with Mr. Howard.
Then you take the assignment. All right, the next item on our agenda has to do with the Department of Environmental Quality.
I'm sorry, Ben, you got,
Oh, by the way, before we go on, I did receive some, no, I did not receive any information. I would like to place into the record a piece of evidence that was supplied by facts about the neighborhood conservation. And staff report also. Do you have the report? That goes what? No, it goes with this.
Alex, hey, this thing.
All right.
It's a known.
All right, so that's done.
Bathroom break, sir. Quick bathroom.
Yes, it's going to be quick. 7 minutes.
Mr. Harold, so I guess it's.
Bathroom break.
Really? Wednesday?
No, well,
Monday?
it doesn't matter.
This is for you personally. Put it in your purse and read it tomorrow. I gotta go to bed.
If we make a big deal.
I'm gonna make you guys make decisions.
Yeah, I like it like they approve my but you've got to go back and do
Have you ever seen a more
And I've been doing it for 20 years.
Yeah, you do it twice as long as me, and I
and the big
anything as I'm so uncomfortable, childlike, as they were out there.
I started to get scared.
Yeah.
It is.
Thank you.
Like, hey, likes to take temperature. I wasn't there. It's a parking lot, right? Yeah, I've been walking the parking lot, right? You know, for the so.
Yeah, you know, because every day I'm at my son's ball game, you know, my son watching him play, and it just gets redder and redder.
Like he used to like open it. I know. And you know, we were doing like forest conservation. You know, I said like, these trees are not dead or dying.
Sure, yeah, that's I know there's such a thing.
Yeah.
It sounds crazy.
Just letting you know.
Yeah.
I know. I don't think. Yeah. Well, so we should talk about trying to figure out how to maybe that changing ourselves, and then just like clarify. It's just if we do the work for them. I'm not gonna ask.
Yeah, right. That's one way to tell if it works.
Got a whole bunch of other things right now going on. Thank you. Do you know I knew 1, 2, 3, 4, 5, 6 people in the audience. I didn't know her, no.
They get assassinated when they went out. I'm going to wear a wig when I go out of here. A wig and change my shirt. Can I change it with you?
This is crazy. Ooh, my goodness.
Council?
No, 30 days. I was just joking. No, because it's too soon. I mean, I don't, because they've got to come back here, and they've got to be signed. So at the next meeting. Send them to the planning. Yeah, and then. I was just joking about that.
Time is 10:07. Okay. I'm ready. Mr. Harold? There's some people in the room who still work.
Jeez, tough crowd.
Okay. Ordinance 0-1819 to establish a new Department of the Environment. Dr. Nash.
Thank you. I've handed out 3 letters that we received from different organizations and members of the public. All right, this is Ordinance 0-1819, the purpose of which is primarily to establish a new title in City Code, Title 19, which creates a new Department of the Environment and moves regulations from different titles, 14, 17, and 21, into this new title that would have all of the environmental compliance and stormwater management in one department. That means also some of the functions of the departments of planning and zoning and public works would move from their current location to that new department. For planning and zoning specifically, that would be our review of forest conservation. So as you may remember, in July of 2016, the Department of Neighborhood and Environmental Programs was reorganized so that inspections and permitting was transferred to planning and zoning, as was the regulatory authority for the Forest Conservation Act review. And meanwhile, environmental compliance and stormwater management functions were transferred to the Department of Public Works, and a new office, the Office of Environmental Policy, was created. So this office looks at protecting the environment by implementing policies and programs such as grants, policy development, public education and outreach, and watershed improvement, among other things. Meanwhile, Public Works does the stormwater management reviews with their engineer, planning and zoning through our current planning division. Actually, mainly Tom does the checks to make sure all of the forest conservation plans are applied for correctly and follow the code and the forest conservation manual. So we've adjusted to that new structure. We don't really anticipate a lot of forest conservation projects in the future, especially large ones. You know, we're not growing a lot as a city. We don't have any annexations on the horizon. There's really just not that much land in the city that's not in the critical area. Because if you are in the Chesapeake Bay critical area, you're subject to that state law. You are not subject to the Forest Conservation Act state law. So most of what we review is in critical area. A lot of the big projects we've had are Crystal Springs, Parkside Preserve, things that came in with annexations in the last 20 years. You know, we just don't foresee very many projects in the future. And so that is my report. Are there any questions about this new department or how it would affect planning and zoning?
Who currently has authority or jurisdiction over the Forest Conservation Act?
Planning and zoning.
And who in the office is doing that?
Tom Smith.
Okay, and what about stormwater? How do you handle stormwater?
That's done in the Department of Public Works by their stormwater engineer.
Okay. Now, stormwater. You have somebody in a different department looking at stormwater, and stormwater management is also a part of our site design review, correct?
That's right.
So what happens with the decision of the Public Works employee, the stormwater employee, when it comes for P&Z review? What happens with that decision? Can you override that decision?
Well, so if we are reviewing a project, which means we're doing a plan development, special exceptions, site design, we send those plans out for agency review and receive comments back from different agencies. Public Works is one of those agencies, as are, there's many different agencies we get comments from: Transportation, Rec and Parks, Health Department. Okay, sorry. And so a lot of times the staff just takes the comment, sends it to the applicant, and we move on. There are times when some specific aspect of what an agency is asking for does conflict with something either planning and zoning or another agency is asking for. Then we do have to negotiate how we're going to move forward. And we rarely, if ever, override someone. We usually try to work with someone to figure out how we can both get what we need to from the regulatory perspective in a way that satisfies all of our conditions.
Well, here's my concern. In my experience, there are people who do like the forest conservation or stormwater. The one guy is a forester, and then over in the water side, the guy counts up volumes of water and storm, anticipated storms and so forth. But over in planning and zoning, it's a much more, I guess the proper word, even I don't use it much, is holistic, in which you're looking at how does stormwater management fit into the design and the use of this land, and what can be done in terms of forest management or tree management that incorporates into the whole design. And so what I'm concerned about is just what happens with the involvement of planning and zoning, which has a different perspective than sometimes the more limited perspectives of those two stewards. So I'm just raising that as a concern, and I think it might become a theme as we move forward. Thank you. Any questions of Dr. Nash? All right, I'd like to open the public hearing, and I'd like to hear a comment. And if you testify tonight, please fill out the sign-in sheet or you incur the wrath of the clerk.
Good evening. I'm Kurt Beagle from 307 Monterey Avenue in West Minneapolis. This is a subject that I have some professional experience in environmental management, and I just wanted to give you a few of my thoughts on what I think is a very important matter. The city has advanced two proposals to somewhat alter the scheme under which we operate. One, the mayor's
from planning and zoning or from public works or from the transportation department. And by the way, this bill omits from inclusion one of the most important environmentally departments in the city, and that's transportation. As nearly as I can tell, the item of transportation, which probably has more effect on generating stormwater and air pollution effects and so forth, is just not in this proposal. What I think the city should aim at is developing expertise and authority within the departments, but overseen by an environmental director who has real authority. The scheme that I think would be very useful would be an environmental director with dual reporting authority to the mayor for policy and to the city administrator for administrative matters. And that a coordinating and management function for city environmental matters would be handled through a senior environmental council comprising the departments of the city government and chaired by the environmental director. That leaves the responsibilities for execution with the departments that are most skilled in the technical matters of those departments, and it leaves policy authority with an environmental director who is well connected to the mayor and has legal and policy expertise. And that's really the summary. Now, I sent a letter to the three of you that I had email addresses for, and I would ask, Bob, that you share that with the full committee if you can.
We got it here as part of it.
So, look, nuts and bolts here, okay? What you're proposing is that there not be a Department of Environment, that there be an environmental policy person, but who's got some kind of management authority over all issues of environmental, with the environment that come through the city. I'm really trying to get a grasp on that. So help me out here.
Okay. The role that I've seen most frequently is one where the environmental director is a locus of expertise in environmental law, regulation, and policy, with a knowledge of enough of the technologies involved to be able to communicate effectively with the executing departments. At a minimum, the environmental director would have sign-off authority on significant environmental actions taken by the departments. Whether other kinds of management authorities are appropriate, I don't know. That would take further discussion.
Oh, so okay. So there's an application in for 15 townhome developers, and the stormwater fellow has signed off, the forestry person has signed off, current planning and zoning has sort of signed off on this, and then it goes to the environmental policy management person. So she's going to look at 15 townhome unit developments to see if they qualify in all respects.
Yeah, I think
she has to sign off on everything.
I think there should be a review, a backup review procedure of some kind, and all of the department heads would have been involved in something like monthly management meetings on environmental topics. So there would be very few surprises. So that's
a two-headed job.
Yeah. Yeah.
So I take it you would agree that the stormwater management engineer should not be removed from the Public Works Department and put in this?
The environment is connected to everything, and I think to the extent that you're trying to identify several areas of technical expertise and removing them for consolidation
into a single environmental department has its hazards. I think it's better to leave it well connected to the other responsibilities of that department.
What you've described to me sounds exactly like an integrated product team within the United States government, where they leave them in their separate expertise area groups, but then they bring them together under a director who has the authority to make them all together enact in a certain way, which is what integrated product teams do.
It does sound quite similar, yeah.
And what you just said.
Coincidentally, I met today with Matt Johnston briefly. The county is considering similar questions, and for the time being at least has decided that a separate segregated Department of Environmental Protection is not the way they want to go. It's not to say they won't get back to that someday, but that's their present inclination.
Do we have a number of the net increase in city workers from this new department versus what we have? No increase or decrease?
There's a fiscal impact, but not in head count, if I remember correctly. Yeah, it's on. So, yeah, I have one question. So, do you think, in the way it's organized now, if that environmental person in the mayor's office is given slightly more authority, could accomplish that goal within the way things are structured now?
Yeah, I think so. I think so. If there were a real management council, I know there's a Creeks Council, which is something of a hybrid between outside advisory outside advisory input and internal management. But what I have in mind is really strengthening the internal management within city government.
But that could be done just by policy and not in legislation. I mean, that if there were a commitment by the administration to
the advantage to legislation would be in defining the relationships clearly enough that they are durable through changes of administration. So so I would recommend that this legislation be discussed further. It's a good proposal. The proposal for a department is a good one. It's aimed at solving a real problem. But I think that there are some hazards that we should be aware of and try to work around.
Okay. Thank you, sir. Thank you for waiting through everything you had to wait through.
I rushed. I knew I was late, and I was...
Did we get your experience of how you were involved in this type of work? Exact titles?
I was a director of environmental technology for the Environmental Protection Agency in the Office of Research and Development. I was the founding director of the Office of Environmental Protection in the Naval Sea Systems Command and director of environmental technology for the Secretary of the Navy. And these are the things that I have found in my own experience to be useful ways of looking at things.
Anybody else who's going to wish to speak tonight? Alderman Savage.
Can I say that Steve Payroll?
Sure. At this late time? Of course. At this late hour, of course.
Yeah. Thank you, Commissioners. So it's Rob Savage, Alderman, Ward 7, 12 Windwhisper Lane. So I think, grab my paperwork, sorry. Mine's under my tablet.
Is the microphone on?
Yes, it's on now. So does everybody have my legislative brief Was that provided? I do have copies if it was not. No? So I'm not going to read through that, but I did want to just start off by naming a few of the individuals and groups that have testified, not to this particular legislation because this doesn't come back to the council for a public hearing yet, but they have commented on the other pieces of legislation that are connected to this, which is primarily a charter amendment. So some of those groups were the Annapolis Environmental Commission. We had Amy Clements with the Spa Creek Conservancy, David Barker with the Severn River Association, Betsy Love with St. Luke's Restoration, Jesse Iliff with South River, Arundel Rivers it's called now, Darlene Finch with Eastport Civic Eco Action Committee, and Jack Turner with Back Creek Conservancy. So I'm just going to start by going over a little bit about the background of, in particular, some of the city's environmental organization. I'm going to not reiterate what Sally went over. I'll try to just give you some other perspective and history to it. So, first of all, DNEP, the Department of Neighborhood and Environmental Programs, was created underneath Ellen Moyer, I think around 2003. So it's been almost, I guess, 15 years. That department combined environmental programs with code enforcement. And at the time, it included five environmental positions. It had the chief of environmental programs, you had the city forester, and an environmental compliance position, which also served as sustainability coordinator. You had an environmental program coordinator and a stormwater management engineer. So that's 5 positions. And at the time, I served as the sustainability coordinator, environmental compliance inspector. So we worked quite closely with other departments, so planning, zoning, and public works especially, and in particular when it came time for the Forest Conservation Act review and stormwater management reviews. Not to mention we worked together on things like the sustainability plan, climate action plan, and the tree canopy goal, all of which we successfully had integrated with the comp plan coming out of planning and zoning. So it was like this for nearly well, I guess actually it was like that for probably about 10 years or so, 13, with the forest conservation and stormwater programs within that environmental program division. And then as Dr. Nash said, Pantelides dissolved DNEP, went from 5 environmental positions down to 3 because the stormwater management engineer went to public works, and they got rid of the chief of environmental programs position. So the idea was for that Office of Environmental Policy to have full authority of the city manager's office. And that's why the office was put in the mayor's code, but it was also put under direct supervision by the city manager. So when I spoke with a former director, she'd said this change was sold to her by saying she would be essentially second in command, right underneath the city manager with their authority to get things changed within the departments. So at the time, the acting city manager, who was Director David Gerald, said at the time this office could be empowered or weakened by the city manager. And I think this represents a flaw in the organizational structure in the sense that it was allowed to kind of be at the whim of other forces. So I think both organizational structures have merit, but as an environmental scientist and someone who has studied organizational behavior, I'm trying to adjust my proposal based on my observations, experiences, and that of those who've reached out to me. So I think DNEP certainly had leadership issues, but we had great staff, regulatory authority, and a team-driven collaborative approach. The current Office of Environmental Policy has great leadership that's been able to collaborate with other departments. It's also accomplished quite a bit, but I think it's held back by a lack of regulatory authority and the ability to really require change. And I also want to say, I think it's best when reorganizations are considered that they're separated from personnel. So what I'm trying to look for in this go-around is what type of organization, what kind of system can we build to provide the most success for the environment, regardless of who is in these positions. So I've been mulling over these changes for a little while, and I did speak to Adam Ortiz. He's the director of the Montgomery County Department of the Environment. Before that, he was director of Prince George's County Department of the Environment. And he listed 3 things to me which he thought were essential for a successful environmental program. He said, first of all, is staff and resources. Second is a team with a dedicated mindset focused on the environment. And the third was a regulatory authority. And so I'll be hitting some of those themes in the rest of my testimony. So when the city manager and the mayor introduced their proposal to dissolve environmental policy, without speaking to the entire council or the community, I decided to react with my own proposal much earlier than I anticipated. But I held an environmental summit with about 40 people and organizations who attended to gather input, not just on this proposal, but on, in general, what their concerns and interests were. And so I mentioned that to go over what I and I think many in the community see as a need for change, a need which I believe originates from the environmental programs being, essentially, they've ended up being diluted in these larger departments. So the public's expressed a number of frustrations. First of all, the Forest Conservation Act reviews, which are currently in plan and zoning. We had a bit of an issue with implementation of the no net loss ordinance and policy. I think this could have been avoided with a dedicated Department of the Environment. I think the Forest Conservation Program could also benefit from having environmental scientists, along with the professional planners and landscape architects who currently are involved with the process, but to have the other scientists, and in this case the city arborist, involved in the review and the approval process. Another issue I've heard is having to do with the stormwater management reviews, which are currently in Public Works. And again, these were done for many years through the Environmental Programs Division. But in this case, you may recall, Public Works they weren't quite enforcing our stormwater law to the maximum extent possible. And so the council ended up passing a resolution to essentially give them support to do just that, which I think is great. And they've actually exceeded the council's resolution, which is great, again. But I feel like the fact that we had to push them kind of shows that we could benefit from an organizational structure that really fosters the environmental innovation and leadership that many are seeking. Another concern I've heard a lot about comes from the watershed organizations, the nonprofits who are really doing the lion's share of restoration work in the city. And they've had some challenges with the reviews and the approvals and the inspections coming from Department of Public Works. And I think that's a product of having the environmental stormwater reviews under a department that really, I think, it's not a criticism, but they're focused on their engineering concerns, and that's the perspective that they come from. I think that's one reason why the county has set up a separate watershed protection and restoration program. It's still within Public Works, but it has its own goals and drive for sure. Another concern I've heard are kind of with, again, stormwater management program, and in this case, some missed opportunities. For example, with Main Street rebricking, the downtown pumps, there were opportunities where we could have looked at permeable pavers. We could have looked at other green technologies, filters on the downtown pumps. And Public Works did look at these after the community pushed, but I think if there was a Department of the Environment who had some more involvement with that review process of these projects, I think that could help resolve that issue. The last issue I've had brought to my attention has to do with sediment and erosion control enforcement, which again is currently done in Public Works. You're probably familiar with some of the concerns we've had with Milkshake Lane, also the Key School project, which is in the county, but it turns out they have sediment that ran into the city. And we've had some difficulties with enforcement on those projects. So this isn't meant to be a criticism of staff. I've worked with a number of these people for many years, and they're incredibly capable and talented, and they're very conscious of environmental concerns. But that doesn't mean that our environmental programs wouldn't benefit from being given even more focus and attention that I feel a dedicated department would bring. So what I'm trying to respond to some of these concerns and identify areas where we can make improvements. And I'm not trying to cut out any of the departments. I think they should still have a role in the reviews and in the environmental programs. One change I'm contemplating and trying to figure out how to implement it would be enabling a dual review authority. I think we kind of had it underneath the DNEP for a while, but so it'd be a dual review authority for both planning and zoning and public works, with the proposed Department of the Environment being the primary decider and with the regulatory authority. So in terms of what my proposal would do, again, I'm trying to build this organization for environmental success, but the first thing, it would put regulatory authority for the forest conservation, stormwater management, and sediment erosion control, and floodplains directly under this proposed department with its own dedicated environmental title. Because as you're probably well aware, we have three different sections of code that deal with trees and forests. And this would put that all under one section. Number two, it would ensure that our environment has the focus that a dedicated team and department would bring. Three is it would create a one-stop shop permitting for environmental permitting for these restoration projects. Four, it would propose to create a middle manager, although it turns out this may not be needed after we spoke with the current director, and it turns out only about 10% of her time is spent on management. The original idea was to free up her time to do more policy, but it turns out that may not be needed. Number five is it would bring in the environmental compliance inspector, which would help to provide inspection capabilities and enforcement to some of these environmental programs. What it does not do is it does not make any substantive change to any of the regulations. All it does is move the authority to a different department. So just to end up here, I'm here not only to explain my intention, but to hear your feedback and ideas. I want this to be a collaborative approach, even if that means scrapping the idea and focusing on ways to improve the current structure. I think there's no rush to this because it's being done, at this point, it's being done separate to the budget. So if the commission feels like they want more time to discuss this, I think, again, there's no rush because how the timeline is going to work, there's no way this is going to get done for the budget. And I think the council is pretty clear. They want to separate the reorganization from the budget, which has a lot of other large things to discuss. So some things I'm looking for feedback on are the organizational approach and the need, ideas on how the dual review authority may work between public works and planning and zoning, refinement of the one-stop shop permitting idea, and just plain feedback on, from your perspective and experience, would such a change be beneficial or needed? Because obviously it would, and I think hopefully have a positive impact on how development projects are reviewed. So I'll end it there, see if you have any follow-up questions for me.
The Annapolis Environmental Commission made some comments to us, and do you have a rebuttal to their recommendations in bold?
I don't have that handy, their comments. But.
Okay, well, she'll provide you a copy, and we'll talk about that later, give you a chance to peruse it.
I think I've seen it already.
You probably have. May 15th it was out, so.
Thanks. Did you have a question about their comments?
They're not in favor of dismantling the Office of Environmental Policy. Mm-hmm. In your reorg, did that happen or not? I mean, it seems.
Well, so the proposal in the budget coming from the mayor is the proposal to dismantle the Office of Environmental Policy. And the AEC, it says, is not in favor of dismantling, but they'd support the creation of a dedicated environmental department. So they're in support.
Does dismantling mean elimination of? You said the mayor's budget proposes dismantling the Office of Environmental Policy.
Yes.
Does that mean that Jackie goes away?
No, under the mayor's proposal, she would become an environmental advisor in his office. And the other positions would have their duties changed and would be put in the different departments.
Should become the what? Environmental advisor under economic development?
No, under the mayor's office. But that is a different proposal. That's not.
And so to contrast then with what you're proposing, that would be that position then becomes part of this 5-person unit that you diagrammed?
Yeah, essentially it would keep. My original proposal was actually just to beef up the current Office of Environmental Policy. And just essentially bring over the stormwater management manager over to that position, over to that office, sorry, and that's all. Just move that one position over and give them some of the regulatory authority. But I had some advice from our previous city attorney, that if an office is providing services to the public, that it needs to be a department. So that's why I shifted, instead of just changing the office to a new department.
I think that's a good idea. And so all those people then would be in one line organization reporting to the city manager?
Yes. So they would be reporting to the director of the Department of the Environment, and that director would be reporting to the city manager, correct?
Thank you.
I just find it duplicative, or maybe an efficiency to be gained, to not having a policy advisor on the environment in the mayor's office and just go to your environmental department for that. Wouldn't you think?
Yeah, I mean, I think that's certainly. I think that's something that could currently be done with the Office of Environmental Policy, is to simply, the mayor, I think, is required by code to have weekly meetings with his director, and he could very simply pull in the director from the Office of Environmental Policy to have that be more integrated.
How does the size of this department compare to other departments? So this would be a staff of 5 compared to other departments in the city?
Yeah, it would be a staff. So there'd be the director of the department. There would be the city forester, the environmental program coordinator, and then there would be at least one stormwater management engineer. If not, we may add a second stormwater engineer in this budget. So, by the time this legislation comes back to the council, we'll know for sure what happens. So I'll have to update this proposal to reflect whatever gets passed in the budget. So that could include moving that other stormwater management engineer.
But in comparison to what's the size of the transportation department at the moment?
That I don't know off the top of my head.
You get a lot of bus drivers over there.
Yeah.
I mean, drivers aside.
Ms. Butler?
Well, I was kind of interested in what Kurt had to say, Kurt Riegel, and then Ben's comment on how it works in the federal government. So it's like a hybrid situation almost, and there would be policy and regulatory authority, and the reporting mechanism would be a little bit different than what's being proposed. But anyway, I'd like to explore whether, Alderman Savage, you think there's a hybrid situation that might work.
Yeah, I think there is, and I think Mr. Riegel's proposal is certainly possible. I'm still not entirely clear myself how we could structure that locally, because I think the one benefit to us being such a small city is we can compared to the county, which, the county has a lot of different departments, environmental duties are spread out, but in the city, we have such a small city, we can collect together the core environmental functions within one department or office. But maybe there is a way to also combine some of the ideas from Mr. Riegel's proposal. Because as he alluded to, I think we do have the Creek Cabinet, which it tries to combine both, including bringing in the public, the watershed groups for feedback, but also it specifically includes the department directors, a few of them, who have environmental issues or duties, responsibilities. And that Creek Cabinet is chaired by the director of the Environmental Policy
And
Office.
how often does that Creek Cabinet meet, or watershed cabinet?
I can't recall exactly what's mandated for that, but they, I think it's at least quarterly, if not more frequently. And then a few of their meetings, not all their meetings, but a few are with the public. I don't think all of them are. I mean, that was just, they've only had one meeting, so I'm not entirely up to speed on that.
I'm concerned about if the current position is moved into the mayor's office, that it becomes irrelevant, and that there's nothing to sort of oversee the connections between water, forest, planning. So that concerns me. So then if I start to take a look at what your proposal is if I am also intrigued by what Mr. Riegel had to say, but I'm not quite sure what it was. So the kinds of things that make me, well, let me list my concerns. I'm concerned about losing the wider perspective of planning compared to the perspectives of, I don't want to be pejorative here, but, guys who just count trees, and they don't count, it's not a wider thing. Okay. So I'm very concerned about that. And then I'm also obviously concerned about the whole notion of the environment being just ignored because it's so dispersed and nobody's kind of looking over it. So what Mr. Riegel was talking about was a hybrid of a person who has kind of supervisory umbrella authority, but not necessarily management. It's not necessarily has like 3 people underneath her, but is responsible for some things, but then also has the time to do policy, which is a laudable goal of the mayor's, frankly. But as you say, she doesn't spend much time on management. I think that's probably wise. So one of the ideas that came to me as I think about this is, I think the idea of a council is a bit unworkable in such a small environment as we have. And I think that what Mr. Smith described as a collegial kind of the water guy said, I'm about to approve this. And Tom says, well, wait a minute, you got a problem because of the whatever he comes up with, or vice versa, And so they talk about it, which is the best way for things to get done without a formal council. So what occurs to me is that if this person has, I heard the word final authority, if her role is that she will resolve issues between departments, or that she perhaps must sign off on anything that has environmental ramifications, which everything does, so that could turn into being a big mess. But you're right, it should be retained only to important matters, which is yet undefined. But what if she were given, she had to sign off on every application? And the same kind of atmosphere prevails as is. In fact, you may put the arborist under planning and zoning. I don't know. someplace, it almost doesn't make any difference. Compliance is important, and she has supervision over all of these things. I mean, she has to be given some authority, but not necessarily a lot of employees. That's the kind of the way that I'm thinking. And that I think that what's underneath what Mr. Regal was saying in a weird way is that decentralizing in some ways is actually could be a goal. Decentralizing people, but putting an authority in place that, I don't know.
I agree with that. I think decentralization.
I'm not clear about it, but I think we need, but the powers and purview and authorities of this position need to be clarified, no matter what you call it. And that needs to be done real clearly, so that issues which arise, I don't know how they'll arise. I'm not enough of a manager.
No, if you look
I
at
just don't have experience with large groups.
Look at our planned developments when they go out and they have to get signed off by forester has to sign off, a stormwater engineer.
Right.
They already have to sign off. This didn't make, I guess, the director of that department that's overseeing those people also have to sign off.
Yeah, I think so. That's a
I
minor.
don't know if it's really affecting that part of the whole deal. But, I mean, it's maybe helping it get more instituted in the review process?
I don't think it's a big addition to the review process. I don't think that it would be. I do think if you're serious about this, you need to put in, city projects, county projects, and state projects as well.
In terms of when they come in for review?
I mean, technically, we have purview over all anything done in the city. And so you might think about that. It's a little bit off on the edges of things. But, hey, what government does has a lot of effect.
Well, yeah.
Do you understand kind of where all I'm trying to do is try to clarify this and keep things as simple as possible. And give people the room to operate as people, but make sure that authorities are clear.
I just don't want to create way too many more positions.
Yeah, right. I got you.
And it sounds like, from what I read in your summary here, which is great, little to no cost for things, and more inspectors, it almost sounds like, at no cost. And I don't know how we do that, but really what I guess you're looking at from us is what really affects us in all of these things is the Forest Conservation Plan taken out of Title 21 and going into a different title. I'm assuming you're probably for that, because that's less work for you. Somebody else does that, and it still gets reviewed and done.
He's not.
Or are you not for that?
Why are you not for it?
Did I ask the wrong question?
No, you asked the right question.
I'll go home. I mean, that's really what
it's the right
I would
question.
think Mr. Savage wants.
I'm happy to have less work. However, as a practicing landscape architect for more than 30 years, the base foundation of development is how you do the analysis and the original concept for those plans. And you really must have a strong background in design and how we're going to manipulate a natural environment into a built environment. And an environmentalist, much like an engineer, sometimes has just sort of narrow focuses versus a more broad focus in how you're going to manipulate those. So while I'm happy to have less work, at least the way that Rob was talking, like some dual authority. So even though it's been in DNAP, it's been in planning and zoning, there's always been this almost, I hate to say, a dual review, but both departments coordinating very closely on forest conservation. Even when it was in DNAP, who did the nuts and bolts, planning and zoning still did the design review.
Wouldn't it still happen that they would coordinate, though, even though they're under a different title in a different department? That coordination would still happen? I would hope we would coordinate our departments.
There was sometimes rub with that in the past. I think it depends on who the person is that's heading that department, frankly.
So it was better and moved into 21 because of that? Or
I think
it's not moved into 21?
From a development responsibility, yes. Maybe I'm not
so not good
that.
to move out of 21 is the basic.
That's my opinion.
Ladies and gentlemen, it is 4 minutes before 11 p.m. I'm noticing a few people who are looking a little dim around the edges. Since there's no particular hurry on this, and we've kind of started the discussion, we've raised some ideas, perhaps we could hear back from you, even on a sketch basis, you know. Would you consider continuing this until June the 19th? Do we have so much to do on the 19th? We have the MPDU legislation in which there'll be a number of people talking.
We have 3 ordinances.
3?
NPDU, APF traffic, and the other one, dwellings above the ground floor of a non-residential.
Do we have to hear that on the 19th?
We could always put them on. Well, it's up to you.
Oh, that's no problem.
Another year will matter. Oh, that's a her. Where is she? Okay, let's consider that. I'm told that Ms. Sutherland would like to speak. I didn't know that.
Yes, thank you. I'm Teresa Sutherland. I'm the city manager. I wanted to answer Mr. Pline's question about the size of departments. Currently, the smallest department is the Office of Finance with 22 people. But we are proposing in the FY 2020 budget to create a department for the Office of Emergency Management, and that is 6 people. And if I can answer any questions you have on the mayor's proposed reorganization, I will say very briefly, it takes the forester position, moves it into planning and zoning where all the tree regulations currently reside in the code, and gives that position additional duties, which include being the one with the authority to sign off on the forest conservation plan reviews. It takes the environmental programs coordinator position, which is largely related to stormwater, and moves it into the watershed restoration fund and groups it with the stormwater engineer and the environmental compliance inspector. And the mayor's budget also adds a second stormwater engineer in the watershed fund. It moves the director position that would no longer have supervisory authority over those 2 positions into the mayor's office so that that position can focus on the development of policy, on education and outreach, on coordinating with the stakeholder groups as it already does with using the watershed cabinet, and just the participation in Annapolis Environmental Commission and other groups that position staffs and attends and works with. So that is a brief overview of the mayor's proposed budget and his proposed reorganization. And I'd be happy to answer any questions you might have.
For a city of 40,000, we almost mirror a country in our executive
That's
levels.
the problem.
That's
We have our
exactly
own
where
army.
I was going.
So let me just see if I can summarize. The arborist moves to planning and zoning.
Right,
where
with regulatory
Forest
authority.
Conservation Act would remain.
Yes.
Whatever, all of the water people are staying in Department of Public Works.
Correct.
Okay, and the director of whatever it's called now, environmental policy, becomes just a person in the mayor's office looking to, quote, develop policy and pursue grants.
Yes, and educational outreach and collaboration, and as well, having the authority of the mayor to collaborate with the departments so that we can develop the best environmental policy we can, backed by environmental science and best practices that can be enacted by ordinance. Ordinances are then carried out by the departments.
So I would like, while the hour is getting later, I would like everybody to potentially think about this query. Would the person, this position in the mayor's office, if that person had sign-off, final authority on environmental issues that pass through the city?
I'd have to check with the Office of Law. I don't believe that's appropriate because, as Alderman Savage mentioned, under the charter, operations are carried out by departments, and departments are defined in the charter.
You could call it a department head, and she would have nobody but an administrative assistant under her. She would
So
not
department
have
heads, departments carry out and provide services to the public. not to other.
Okay,
departments.
Without getting, I don't.
I'd have to check with the Office of Law. I don't know whether that would be permitted.
I just want to, I want the person to vote, anyway, we've had enough discussion, I don't need to repeat myself, but that, I would like to throw that out as a possibility, to give the person authority over yet to be defined field of operations. I mean, I'm not making, it's late. Question?
Yeah, may I just a clarification on the mayor's proposal. It would move the positions, the stormwater management engineer, I'm sorry, the forester and the environmental program coordinator to different departments out of the Office of Environmental Policy. But a part of that is changing their duties. Some of their, well, at least with the environmental program coordinator, some of her responsibilities are being removed and given to the new policy advisor. And that does concern me because it's a lot of responsibilities for one person. And we would lose some capacity over some of the sustainability program, environmental stewardship program. And I think you may remember Ellen Moyer. She actually had an environmental advisor in her office, Steve Carr, on top of an environmental department. And if I could just throw out one other idea for you to mull over, something else I've thought about, considered, is actually putting an environmental office into planning and zoning. You've had a separate office, environmental program office, but the only challenge with that is, and you can even put stormwater management in there. That's what a number of other jurisdictions do, is they have stormwater management in planning and zoning. But I think the challenge is that you would also, at the same time, by not having a director level or department level position, you would lose some of that interdepartmental authority, right, to work with the other department. I think staff would still work together, but for example, they wouldn't be called to the mayor's weekly meeting with department directors to help provide that, like I think what Mr. Regal is saying, to provide that influence overall of the other departments. But that is something I've given some thought to see if that's doable.
So this is not the mayor's plan? I mean, because what you said was the city forest.
That's my proposal. I mean,
that's your proposal,
yeah.
But not the mayor's proposal.
Right, and I think we'll know Monday, I think, but I believe, just to be frank, I don't think the mayor's proposal is going to pass. We've had 3 or 4 committees recommend unfavorably to that proposal, which means we're going to be starting from scratch in terms of how do we adjust Office of Environmental Policy. Do we want to use my ordinance or amend my ordinance to be some kind of hybrid? But I think the mayor's proposal is going to be off the table after Monday.
Okay.
Is the public hearing still open?
I was thinking about continuing it.
Well, are you going to continue to, I just have 3 quick.
You have 3 minutes.
Okay.
I'll give him more than that.
I do believe that we need to have a dedicated professional environmental staff that spans administrations. They're protected by civil service, and they continue to do their analysis. I do think we need to have sign-off authority by a person directing that department, or whatever you want to call it. You can have all the environmental policy you want. If you're not signing off on project by project, you don't have environmental implementation. And I do believe that planning and zoning needs to be and will be still involved in it, because all the projects are coordinated by planning and zoning. They'll be coordinating this department sign-off like they do public works, like they do police, transportation, and so forth. And I think that's a good thing. And I certainly would want to see Tom, with his experience, staying involved in this, the processing of these projects. So, and I think we can have collegial relationships. I don't want to see us have frictions amongst departments. But if you don't have sign-off authority, you can have 1,000% tree canopy goal. If you don't sign off on the projects, you don't have environmental.
Right.
You just don't. That was less than 3 minutes.
Right. So we need to think this through. I think we need to We need to think it through, take it to another step. It's been very good. Do I hear a motion to continue this public hearing until the next appropriate session? I mean, I'm being procedurally very informal here. I'm not sure we're going to have time on the 19th, but then we get boosted into August, early August. You okay? Okay.
There's no.
All right. Well, we'll do what we can to get to.
Oh, you mean the meeting would be in August?
What? Excuse me?
Did you say the meeting would be in August?
The meeting will be in August.
Well, that's fine. I may not. I'll probably be in Hawaii, but I'm not going to tune in. But I'll. Yeah.
So moved.
Okay, yeah, that's right.
Do you need an adjutant? Well, I'm going to try to keep it going. But
Second.
Help me out.
Even if I'm not here, I'd still think the discussion would be. I'd
Do I
appreciate
hear
the
a motion
feedback.
to continue this open public hearing?
So moved.
Second.
Second.
Discussion. Vote. All in favor say aye.
Aye.
Okay. I don't believe there'll be any new business we have to discuss tonight.
No, there's nothing pressing. I was just going to give you
Okay.
an update.
Okay. I think I'll try to coordinate with Dr. Nash for the next meeting and kind of bring us up to date on comp plan and what we can do about that. Maybe even start it off with that while we're still fresh. Do I hear a motion to adjourn?
So moved.
So moved.
You guys are so speedy. Second? We have a second? All in favor?
Aye.